Gentlemen, please make sure your phones are on silent and they are away. Thank you.
Please rise. The Justices of the Appellate Division Supreme Court First Department, please be all of us having business with the Appellate Division. When ready to give attendance, you shall be heard. Please be seated.
Good afternoon and welcome all. We're about to call the calendar today. We have a busy calendar, which is usual, and certainly we have more requests for argument time than we have argument time. So when I call your case, please ask for the time that you reasonably believe that you need in order to make your arguments. I want to assure you that we have all your briefs as well as the records on appeal, and we've had them for quite some time before argument today, so you should bear that in mind when you request time. Also, if I give you less time than you request, it's not a reflection of what we think about your case, it's what we think about the time that exists in any particular afternoon at the court. So the first case is People versus Espinal. Submit. Ford v. Haar. Right, I'm going to give you 5, 2, and 5. Michael K. versus Harlan M. It's up to you. All right, I'll give you 3 minutes. Linares versus City of New York.
Alan, 5 and 2, Your Honor.
All right, 5, 2, and 5. Thank you, counselors. There are 2 cases, People versus Cannon. We'll submit them both. Westco Insurance versus Salvo.
Appellate, Salvo, request 3 minutes.
Do we have the other respondent? Trividi? All right, I'll give the appellant 5 and 2. Salvo, you have 3. And the co-respondent is submit. Flores versus 215 East 68th Street. Right, appellant, you have 5 and 2. Respondent, defendant 5, plaintiff 3. Plaintiff 2, you requested, you have 2. People versus Mabel. 4, 1, and 3. Thank you, counselors. Alpine Custom versus Your Season. Sorry if I mispronounced that. What, do we have an appellant? Considering that we don't have the appellant arguing, do you want to submit or perhaps revise down the time that you need? How about if I give you 3? Thank you. Cohn versus Cohn.
Good afternoon, Your Honor. Appellant requests 8 and 4. Respondent Cohen 7, Your Honor. Respondent Icus 4, Your Honor.
Okay, appellant 5 and 2. Respondent Cohn 4. Respondent Icus 3. People versus Cutts. Submit. People versus Bonilla. Submit. Darby versus Libach.
7 and 3, 4 for the appellant, Your Honor. 5 for the defendant respondent, Your Honor.
Give the appellant 6 and 2, 5 for the respondent. McQueen versus City of New York. Submit. Ordthan versus Nick and Duke.
Appellant, respondent, 8 and 3, Your Honor.
Defendant cross respondent 8.
I'll give you each 5 and 2. People versus Rios. Submit. People versus Fleming. All right, 4 and 1 for appellant, 4 for respondent. Papadas versus City of New York. 5, 2, and 5. Thank you, counselors. Sierra versus Halton is a submit, and Feliciano versus Los Chavales, submit. First case on the calendar is Fort v. Har. I am disqualified from that case.
Good afternoon. Daniel Notice for the appellant, Dr. Har. May it please the court. We believe this is a straightforward appeal, Your Honor. The word consummation may have many different meanings, but in the context of this prenuptial agreement between these two parties, it means getting married, which is what these parties did 6 months after they signed their prenuptial agreement. Not only did they get married, and their marriage certificate, signed by both the appellant and the respondent, certified by the local clerk in Florida, is in the record, but respondent accepted 2 benefits after their marriage. She got an automobile pursuant to the prenuptial agreement, and she got a marital award also pursuant to the prenuptial agreement. Justice Gesmer, you were on a panel called Bradley, affirming Justice Cooper, where this court, among other things, affirmed a settlement agreement between spouses based on the ratification of a spouse.
Let me ask you something. Is there anything in the agreement that actually supports consummation the way that the court interpreted it?
The way the lower...
Anything in the language of the agreement?
So, Your Honor, if you look at the, I think it's 58-page prenuptial agreement, I don't know if I can use the word in court, the S word, but what the lower court actually directed be heard, sexual relations between the parties, is not found anywhere in the agreement. In fact, when you look at the first beginning part of the agreement on page 2 of the prenuptial agreement, there's a heading. It says general intent. So the entire purpose of consummation is actually set forth in the agreement. The parties since 2012 were living together pursuant to a non-marital cohabitation agreement. Upon their marriage, on Valentine's Day of 2015, the cohabitation agreement pursuant to page 1 of the prenup was supposed to become null and void, and the prenuptial agreement was going to replace. So again, consummation in this context, Your Honor, means completion, getting married, and that's what the parties did here. There's no ambiguity with that word. The next thing I think which is important here is not only did respondent ratify the prenuptial agreement twice after the wedding, but in October of 2020, within 10 months of her commencing this action, she had my client sign a modification agreement, which again, on page 2 of the modification agreement, it reaffirms the prenuptial agreement signed by the parties. One of the issues with the respondent's pleading in the lower court, she is the plaintiff in that case. She commenced the divorce action, She didn't seek an annulment. She filed for divorce on the basis of no-fault divorce, and what she wants this court to adopt is a theory that you can have an effective agreement, because she concedes the agreement was effective. She's ratified it by her conduct, but she says it's non-enforceable. So in the commercial context, that would be akin to having a lease with a landlord that's effective, but no remedies, because it's not enforceable. What the respondent fails to rebut is the fact that the prenuptial agreement has a section before you even get to Article 6. She waived any defenses to enforcement of the prenup. And the general statement of intent on page 2 of the prenuptial agreement is incorporated in the body of the agreement. So what she wants this court to do is disregard the litany of cases. This is a contract case, right? Marital agreements are reviewed as any other contract. And what she wants this court to do, and what the lower court basically did, is cherry pick one word from a 58-page prenup, disregard the fact that she told the federal government and the state government they were married for 7 years, the tax returns, right, the Mahoney-Buntsman argument. She held herself out to the local government in Florida when she got married. She filed tax returns for 7 years with my client, and all of a sudden she wants to get a divorce. She says, oh, we never had relations. And what she wants this court to do is basically adopt a policy where if a spouse doesn't have sexual intercourse or sexual relations, there is no enforceable prenuptial agreement. And that's a very slippery slope, especially when you look at the forms on Westlaw, 22 other jurisdictions. Consummation means a variety of things, but it doesn't mean the one thing the lower court said it means. And obviously the hearing, which this court has stayed both by the interim order of Justice Rodriguez and the full motion panel, that would be a hearing, from what we've researched, the first time in the country, especially in this state.
And isn't it also, wouldn't that interpretation also be inconsistent with the provision of the prenup that says that the purpose of the prenup is to avoid intrusive proceedings?
Justice Gesmer, the general intent right at the beginning of the prenup was for that purpose, and it's in the record. They both had very experienced matrimonial counsel representing them. The agreement was heavily negotiated. She lived by the agreement, and unfortunately, having a new lawyer when you get divorced doesn't change the fact that she signed the agreement that she signed.
Thank you very much.
Thank you, Your Honor.
Good afternoon, Your Honors. Shannon Simpson, Cohen, Claire Lands, Greifer, Thorpe, and Rottenstrike for Plaintiff Respondent Angela Fort. May it please the Court. I would say that with the exception of Appellant's conclusion, there is much in his argument with which Respondent agrees.
Well, could we start with the modification agreement? I just don't see any way that you can avoid the fact that the modification agreement constitutes a ratification of the original prenup and an acknowledgement that it remains in full force and effect and is binding upon the parties. So it seems to me that I just don't understand what argument you might have to get around the modification agreement as an acknowledgement that the prenup is in full force and effect and enforceable.
I would look to the four corners of the agreement.
So did I. Show me where in the four corners of the agreement the modification agreement doesn't acknowledge that the prenup is still in effect and has always been in effect.
The prenup has two conditions to its enforceability. The modification agreement didn't change that. The two conditions are marriage and consummation of the marriage.
But it says that that the prenup will continue in full force and effect. How can it be in full force and effect if it's not enforceable?
There are two pieces. The condition that the marriage be consummated could be satisfied at any point in time.
So let's go back a minute, because even aside from the modification, you're saying that you're relying on the four corners of the agreement. But I'm looking at the four corners of the agreement, and they seem to very clearly say that consummation is getting married. And I'm going to read to you the language that I'm looking at, and you explain to me how it could possibly mean sexual relations. It says, the consummation of the anticipated marriage is a condition precedent to the enforceability of this agreement. If Robert and Angela do not marry, this agreement shall have no effect. How can that possibly mean consummation by sexual relationship as opposed to consummation by getting married?
I would answer that in two ways, and I think appellant agrees that consummation can have more than one meaning. It can mean sexual relations between a married couple. In fact,
Right, but we're going to look at the language of the agreement, and I'm going to ask you the same question I asked opposing counsel. Where in the agreement is there even a hint that consummation means sexual relations as opposed to actually just getting married?
what I would say is that this agreement uses the word consummation once, and it uses the word marriage 9 times. If they meant the same thing, if consummation of the marriage meant just getting married, then why isn't it used 2 lines down in the exact same paragraph when it speaks about the parties not marrying? It doesn't say if the parties do not consummate the marriage.
So are you saying that whenever an agreement has 2 synonyms in an agreement, one of which can have an alternate meaning, that it has to have the alternate meaning and can't be a synonym?
No, I'm saying that if you're not
Lawyers
sure...
like to use synonyms so it doesn't get boring to write and read the agreement.
Well, if we're asking whether Mr. Felder was boring in his agreements, I don't have any opinion on that. I did have an opportunity to look through his treaties. He never once used the word consummation in it. These parties used the phrase consummation of...
Counsel, let's go on to the next sentence, which to me says the same thing, consummation has to be marriage. This agreement is made in consideration and is conditioned upon Robert and Angela entering into a valid ceremonial marriage with each other, and that shall become effective as of the date of that marriage. How can that mean anything other than consummation is referring to getting married, and once they get married, the agreement is effective?
Look at all, they don't use the word consummation of the marriage. They didn't say once they consummate a valid ceremonial marriage. This agreement uses the word marriage or married at least 9 times.
Aren't you reading a second condition into the agreement that is not present, though? Because the agreement again and again says marriage is what is needed for the agreement to become effective. Where does it say sexual relations is what is needed?
So I disagree that this agreement does not have 2 conditions precedent. And one principle of contract interpretation is to read this so that all of the sentences have meaning. If the first sentence, consummation of the marriage, means the exact same thing as the second sentence, which is that if they don't get married, it's not effective, then why include the first sentence at all? You're really writing it out of the agreement.
Do you have another question? Go ahead.
So as long as I agree with you that every word has to have a meaning, but it seems to me that one of the things that's important is that the prenup says that the party's intention is to avoid unnecessary litigation and intrusion into their lives. Now, all matrimonial practitioners who live through the pre-no-fault period know how intrusive it can be to have a hearing about whether people had sex. So given that their intent was to avoid intrusion, I can't imagine any way that your interpretation of it would be consistent with the general statement of intent. Can you explain that?
What I would point to again is the phrase, consummation of the anticipated marriage.
Well, I want you to focus on the intrusion issue. Doesn't your interpretation result in incredible intrusion into these people's privacy?
I would say 1, no. We're talking about a simple hearing asking whether this couple had sexual relations after their marriage. I would say 2.
And you don't think that's intrusive?
Perhaps under different circumstances, I might think it was intrusive. In this case, a plaintiff appellant has already put in, defendant appellant has already put in a lengthy affidavit attesting to his view of the sexual relations here. If there were a concern with privacy, I would have expected it to be raised before now, and certainly before the lower court. It's a simple hearing. It's a simple question. Even the court below said the hearing is not expected to take a significant amount of time.
Does the court have any more questions? Okay, thank you very much.
Thank you very much, Your Honors.
If I can just keep this very brief. Justice Gesmer, in terms of synonyms, there's the word fix right at the beginning of the agreement. Like every other prenuptial agreement we deal with in New York, it says they intend to fix and determine in advance of their wedding. This is analogous to, in our opening brief, we gave the court the analogy of a wedding band if this prenuptial agreement in the personal property section, which has been ratified twice by the respondent, would have said Dr. Har has to give Ms. Fort a wedding band, right? Is she going to come to court and argue that she has to actually get a full band with a violin and a trumpet? No. The same concept is fixed. She's not fixing a light bulb. She's got, by the way, they both sought out highly experienced matrimonial counsel, and it defies logic. Respondent's core argument, I have a client who's on his first wife died, he's been divorced, very successful surgeon on his third marriage. He keeps saying to me, I signed a prenuptial agreement, she got the benefit of it, I've given her gifts, we've been married for 7 years, and now she wants to have this hearing. And I know it whores the record, but my client did put an affidavit about their sex life because he had no choice. He was required to. And in the lower court, and this significantly prejudiced him, the initial jurist that had this case was prepared to dismiss the case. She told us, we appeared last September once. She set a briefing schedule. We were supposed to appear on the return date. And then we show up to court. My client flew in from Florida, and the court had double booked the court reporter, and the jurist was extremely apologetic and said, I have to put this off, I think, till January 11th. January 4th, all of us get an alert that there's a new judge on the case. And then we have a whole new, when we have an argument.
Is this really germane to an analysis of the legal issue, though?
Well, it is, if I may, Your Honor, because the fact of the matter is the party signed this prenuptial agreement because this case should have been resolved last summer. When respondent commenced the action in the court below as plaintiff, she's required to seek the same relief that's in the prenuptial agreement, which, to answer a question asked of respondent,
You have a second to wrap up your point.
just going to conclude, is consistent with the general intent in the four corners of their document. Thank you.
Thank you.
The next case is Michael K. versus Harlan M. You may proceed.
Good afternoon, Your Honors. May it please the court, my name is Susan Cordero from Simpson Thatcher and Bartlett. We're appearing as pro bono counsel for the respondent mother in this case. The order of the family court should be affirmed in its entirety. The court certainly did not abuse its discretion when it suspended the father's in-person contact with
Let me ask you a very specific question, which is about the portion of the decision which says that upon submission of an appropriate affidavit by a mental health professional, visitation would resume. Could you comment on that?
Certainly, Your Honor. The provision is slightly different than you just read. It stated that visitation in person should be suspended until such time as the mental health professional advises that a resumption of parenting time
What
is
do you
safe.
think of that? What's your position on that?
Certainly. Our position is that this is not an improper delegation of the lower court's authority to the extent that the other cases cited or the other cases looked at by this court have found improper delegation where a parent...
But isn't the court giving up its right to make that determination by delegating it to
It's
a
not,
mental
Your
health
Honor. Its
professional?
order takes effect as is. Visits are suspended. The father is granted the ability to email the child on certain specified days of the week. They have other electronic forms of communication. We did not view that as a delegation or something that was self-executing. It doesn't cite a specific therapist. It seemed to simply reinforce the court's view that the child's delicate mental health was the issue underlying the suspension of visits.
May I ask a
Nevertheless-
question? I'm going to ask a question related to that. So do you understand that provision to mean that if the father believed that there had been a change in circumstances without a certification or an advice by a mental health examiner, could he make an application for modification of the visitation so that he could resume visitation?
No, Your Honor. It would be our position that he would need to return like any other litigant and show a change of circumstances. And it is our
Well, that's what I'm asking you.
Yeah.
Could he show a change of circumstances in the absence of an affidavit or a certification from a mental health professional under this decision?
If the court sees this that way as something that was an improper delegation, We have no problem with simply striking the provision, as this court did in the Linda R. v. RZ case, where the provision that made this until such time as a mental health professional, that can simply be stricken from the order. There's no need to remit for any further proceedings, and the order would
So
stand.
we could sever that provision out if there was a
Certainly
problem
can,
with
with
it.
absolutely no further proceedings required. And this court has done that, and we would, in our brief, we said that to the extent the court finds it to be an improper delegation, it may simply strike that portion of the order.
Thank you.
Thank you so much.
Thank you for your pro bono service, and please be sure to extend our thanks to your law firm as well.
Thank you, Your Honor.
Linares versus City of New York. You can proceed.
Richard Gullo with Sarusian Spring on behalf of defendant appellants. May it please the court. It is our position that the lower court erred when it awarded summary judgment to the respondent pursuant to Labor Law 241 and denied certain portions of appellant's summary judgment motion pursuant to Labor Law 241-6. It is our position that the lower court failed to recognize a distinction in our case such that the case law holds with regards to assembling versus disassembling of structures. Here, we have a disassembling case, so the court must ask itself two questions: whether or not the item that fell on the plaintiff was required securing for the purpose of the undertaking, and two, would the use of a safety device such as a clamp, like respondent suggested in his brief, be illogical and contrary to the objective of the work plan. We believe that the object that fell, the steel beam, was a portion of a sidewalk bridge, and it did not require securing for the purposes of the undertaking.
They could have had a rope on it or a sling or something so that it could be controlled, right? There are many things that you could do to secure it which wouldn't interfere with the process of dismantling.
Your Honor, I believe that it was purposefully unsecured at the time of the undertaking.
But tell me why something like a rope or a sling that could control its movement wouldn't have been safer and not inconsistent with the process of disassembling the assembly.
At the time of the accident, it wasn't something that was being lowered by hand. At the time of the accident, it was just unclamped and sitting, waiting to be passed down.
Well, there's nothing in the record that indicates that when it was supposed to be passed down.
No, there is nothing in the record that states that the specific order of when it was going to be passed down.
And in fact, what there is in the record is the plaintiff saying that in terms of what his task was at the moment to receive wooden beams for the dismantling, that the steel beam that fell on him was not part of that process.
At that time, plaintiff had a wooden plank in his hand. However, during the course of the disassembling process, he was being handed steel beams and wooden beams.
But not this particular one, which was part of the bridge. In other words, he says, I wasn't supposed to be handed this steel beam. And there's nothing, I read the affidavit by the defendants, there's nothing there that says, oh yes, he was, oh yes, we were handing down that steel beam at that time or within a short time thereafter. It just said it's part of the dismantling. It didn't say the sequencing of the events, did it?
It did not reference the exact sequencing of the events. However, during the event, in the record, it shows that plaintiff was receiving both wood planks and steel beams throughout. There wasn't a process of we only hand wood beams, then we only hand steel beams. It's just the process of how the sidewalk bridge was disassembled.
Counsel, how do you reconcile your position with the Hyatt case that this court recently decided in 2021?
I'm sorry, at this point, I'm not familiar with the Hyatt case.
Well, basically, it does apply to the dismantling of the sidewalk bridges where scaffolding was being taken down and it fell, and that this court did find, in fact, that the securing of the tower scaffolding would not have hindered the purpose of breaking down the scaffolding, which is really in direct contradiction of what your point is.
I think At least in the case of the Court of Appeals in Salazar, the court discussed whether the use of the safety device would defeat or be contrary to the objective of the work plan. And the work plan here was to disassemble the sidewalk bridge. And in order to disassemble the sidewalk bridge, the piece of metal needed to be unsecured. And that's why it was unsecured.
Is that accurate, that it needs to be totally unsecured? It couldn't be secured and lowered by, let's say, a pulley or something else?
It's the way the sidewalk bridges, from my understanding, the way the sidewalk bridges are built, you use clamps and I guess nuts and bolts. And to remove those items, I think it would be, once the clamp is removed, yes, it is unsecured, but it's the process of
Why wouldn't you remove each piece as you're removing it and keep the other pieces secured until they're ready to be moved?
Excuse me.
I mean, that's the point, that you only need to unsecure the piece that's actually being removed, and that piece is not being removed.
At that specific moment, it might not have been being passed down, but it could have been the next item that was passed down, and that's why it's unsecured. It's a process of disassembling the sidewalk bridge that
Okay.
they remove certain portions in a specific order.
Thank you very much.
Excuse me.
Everything okay?
Sorry.
Good afternoon, Your Honors. May it please the court, my name is John Shaw for the plaintiff's respondents. Just on a footnote, the Salazar case is a trench case where someone fell into a trench. It wasn't gravity related. But in a nutshell, as this court has pointed out, the precedent of this court has already decided unequivocally that this is a case that is a falling object that was required to be secured. In the Metis case in 2008, this court specifically said there is no distinction between whether it's disassembled or assembled. You're accorded the same protection when you're working on a scaffold.
And could this have been secured in a way that was not inconsistent with it being disassembled and moved down to the ground? Could it have been secured by a sling or a pulley or lines or something so that it wouldn't just fall, but it would not prevent it from being disassembled?
Absolutely, Your Honor. Putting
And
aside,
how would that be done?
excuse me?
How would that be done?
You certainly would have a rope or any type of sling to secure it, because this particular beam was not being worked on, and it's not supposed to, a 200-pound beam that's 12 feet long is not supposed to fall suddenly 20 feet while a worker is 20 feet below on the sidewalk doing other work. And he wasn't even working on the beam. Putting aside that under the Zimmer case and the precedent in this department as well, which is cited in my brief, plaintiff doesn't even have to show what safety device was necessary, but clearly a safety device was supposed to prevent something like this from happening. And in fact, since Metis, counsel respectfully is wrong about the law. Under the Singh case and the Sajowski case, which Justice Gish was on, at the time of Sajowski, the plaintiff was actually removing a portion of a window. He removed the bottom portion of the window, and the top portion of the window suddenly fell while he was actually doing that specific work. In the Singh case, they were dismantling the scaffold and a sidewalk bridge, and the scaffold collapsed. In fact, in the Gonzalez case, which Justice Kern was on, that's not cited in my brief, Gonzalez v. Paramount Groups, 157 AD 3rd 427, they were removing cinder blocks, and a portion of the cinder blocks that were not removed suddenly fell and struck plaintiff, and this court held that irrespective of the disassembling, the portion was supposed to be secured. Here, it's much even stronger than Metis, which was an 8 to 9 foot drop. My client, as a worker, is supposed to be accorded the proper protection for a portion of a scaffold that he wasn't even removing, or no one was removing, suddenly falls 20 feet and weighs 200 pounds and breaks his ankle, resulting in 2 fusion-related surgeries. So they have the burden, and they failed to provide a proper safety device to secure this for the same reason why this statute was enacted. But if this court has any other questions, I will rest on my brief.
Any questions? Thank you.
Thank you.
Any rebuttal?
Your Honor, with discussing Metis, the entire position presented by the plaintiff in that case was whether or not Labor Law 240 applied because the load, the steel beam that required securing for the purpose of the task at hand of assembling the scaffolding was unsecured and the protective device was absent. So those particular clamps that the court discusses in Metis were absent in that case while they were assembling it. Here, those clamps that should have been used in the assembling of the sidewalk bridge in Metis were purposefully unremoved. And that's the distinction with the disassembling case. Additionally, to discuss at least 2 of the cases that he discussed, at least with Sajowski, with the lack of a bracket to hold the window, the court recognized that every other window had the bracket to keep it from falling, and that particular window, the bracket was missing, and that's why it fell. So it was the lack of a safety device that was present on all other windows while he was working. With Sign versus City of New York.
You're not denying that there was no safety device here. You're saying one wasn't required.
That's exactly. We're not denying that the steel beam didn't fall, and we're not denying that there wasn't a safety device present. Our position is that the safety device which was originally present, the clamp, was purposefully removed in order to complete the task at hand.
And getting back to my original question to you, the sequencing of events and the dismantling, in your opinion, bears no relationship to whether something should be secured safely or not. As long as it comes within the rubric of dismantling, all's a go.
I don't necessarily.
It's a hard question.
I don't necessarily. I wish I had more than 2 minutes to answer.
I'm not stopping you.
Well, I think in a general sense, the labor law, at least in Metis, Labor Law 240 applies to disassembling as well as assembling cases. That we're not denying either. That's what Metis stands for. However, in this instance, the steel beam that fell, as much as unfortunate that it did fall, it's not something, it was required to be secured. You know, if I wanted to take a certain piece of, one of the pieces of wood or metal, you have to remove another one. So you can't really pass them all down and remove them all one at a time, just based on the way that these structures are built and designed with cross beams and headers and clamps. So sometimes, at some point, you're going to have to unsecure the item, and that's...
That may be true, but that wasn't in the affidavit of the defendants about what was going on.
In the affidavit of the project manager, I believe it's paragraph 8 on 547 of the record.
He just talks about common practice. He wasn't talking about this particular sequencing of events. It wasn't like, you know, we're going to hand down the wood beam and then the steel beam was next, so it was ready, or it was, you know, in this sequence it was coming down. And that's where, quite frankly, I think my colleague's reference to the Hyatt case is significant in the context of this argument. But we'll see. We'll take a look at it. Thank you. Thank you both.
Thank you, Your Honor.
Wesco Insurance versus Salvo.
Good afternoon, Your Honors. Max Gershwire for Plaintiff Appellant Wesco. The lower court provided no substantive reason for denying Wesco's summary judgment motion because there is none. First, as Salvo conceded in her papers below, the policy that Wesco issued to the condo board does not cover the surviving claims against them in the underlying defamation action. With regard to the policy's general liability coverage, the underlying claims are not covered based on a policy exclusion applying to statements that are first published before the policy incepts. There's no dispute that the alleged defamatory statements that the court in that action found to be actionable were first published before the policy was issued. For that reason, even if similar statements were published when the policy was in force, the exclusion applies. Indeed, both defendants have successfully sued the condo board's prior insurer, general liability insurer, for coverage for that very reason. With regard to the policy's directors and officers coverage, two exclusions apply. One for claims made by any person who ever was a condo board member, as the underlying plaintiff undisputably was, and one for defamation claims, the remaining claims in the underlying action. Because all claims against them are so clearly excluded, the plaintiffs focus instead on, the defendants, on arguing that Wesco is stopped from denying coverage. Because they claim the joint defense Wesco originally provided them has prejudiced them. Setting aside for the moment whether they were actually prejudiced, this argument fails based on the well-settled rule that estoppel occurs in this context only if the insurer failed to promptly reserve its rights, thereby lulling the insured into believing it would be covered for any judgment against it, and thus that it need not consider hiring its own counsel.
Counsel, can I just ask a question as to Travati? Was there any reference by Wesco to Travati as being an officer, and if so, does that matter in this context?
Well, there's no dispute that Trivedi was not an officer. He operated as the head of the real estate management company. For that reason, he does not qualify as an insured under the policy's directors and officers coverage part. But that's only a partial defense. The complete defenses that we're referring to are the exclusions that would apply whether or not Trivedi was an officer of the condo board. So here there's no dispute that Wesco set forth its potential coverage defenses from the beginning, thereby providing the defendants with the choice to retain their own counsel. That the defendants did not seem to receive the message that Wesco was actually disputing coverage until it filed this suit years later is not a viable basis for claiming estoppel. But even setting aside this absence of justifiable reliance, Wesco's actions as respects their defense caused them no prejudice. First, as I alluded to earlier, the defendants have successfully sued the prior insurer, and thus will be covered notwithstanding the outcome of this action. Given that circumstance, there's no possible prejudice. Indeed, to prevail in those coverage actions, the defendants had to overcome the prior insurer's late notice defense by establishing that that insurer was not prejudiced in its ability to defend them by their delay in providing notice, a delay longer than Wesco's delay in filing this action. The defendants are thus also judicially stopped from claiming that Wesco's purported delay has prejudiced them in their defense. In any event, Wesco agreed to provide them with separate counsel soon after their appeal of the order denying in part their motion to dismiss was affirmed, and months before the underlying plaintiff filed a note of issue. They thus had a reasonable opportunity to assert cross-claims against each other and pursue discovery. That they failed to do so is not Wesco's fault. If there are no further questions, I'll reserve any further comment for reply.
Any further questions? Thank you.
Good afternoon, Your Honors. Eric Dinocenzo for Appellate Silvina Salvo. One thing I wish I had stressed more strongly in my brief is that the denial letter or disclaimer letter in 2016 from the insurance company did not specifically disclaim coverage under the directors and officers part of the policy to my client, Silvina Salvo.
Directors and officers, doesn't that have an exclusion for defamation?
For defamation, yes, but that,
So if there's a clear exclusion for defamation, and clearly the only remaining claims are defamation, why wouldn't that exclusion apply on its face?
because the exclusion was not raised in the disclaimer letter, and thus the case law says it is waived. And here you have 4 years that pass during which a
Isn't it a lack
defense.
of coverage, though, rather than an exclusion that we are not covering for defamation cases?
No, that's, it's respectfully different, Your Honor, because it is a exclusion in the directors and officers coverage, and it's a different analysis there than whether or not there's coverage in the first place. There is coverage in the first place, then there's an exclusion, and the exclusion was never raised in the letter, which is harmful to policyholders if then they're provided with the defense, they're going along with the case, their actions are all based on having coverage, and then the insurance company 4 years later pulls the rug out, and by the way, very much prejudices my client in the meanwhile by mishandling the defense and operating under a conflict of interest. So under the D&O coverage, there's the defamation exclusion not raised. There's the insured versus insured exclusion raised, but the insurance company could have then said, okay, full disclaimer, we're not going to provide you with a defense, but they did. And the case law does say that when the insurance company proceeds to provide a defense, even when they know they don't have to, that there's a repercussion to that, that they are then obligated to provide a defense, especially
Even-
like here where there's prejudice.
Even with the reservation, though, doesn't the reservation take care of that, though?
No, Your Honor, because
Why not?
just because in the last sentence of the letter, insurance company says, we don't waive any of our rights, that does not then give them a placeholder where they can then wait for years and decide to stop providing a defense. In the case law I cite, and I believe it's a dissent by Judge Piggott where he cites that as a general proposition of law, that the insurance company has to act if there's a disclaimer, if there's a right to not have to cover someone under a policy. Now that's different. A reservation of rights can arise in a different context, like say a bar fight where there's assault claims and negligence claims. The insurance company can say, we don't cover assault, but we're going to reserve our rights because we're going to defend you for negligence, but if it turns out that you assaulted someone, that's our reservation of rights. We're not going to cover you in that instance. The facts have to unfold. We have to figure out what actually happened. That's not the case here. The denial disclaimer letter shows the insurance company knew all the facts from the outset, but provided that defense. And then, as I said, they did not take any discovery, so we're on the trial calendar with no depositions, and my client says Trivedi, her co-defendant, mistranscribed her statements in the board meeting minutes, and that's the only reason why she's in the case or being accused of defamation. And if she had had her own counsel the right to early on, she would have been able to take Trivedi's deposition. But she has not been able to do that and is robbed of that opportunity because of the insurance company handling the case in its own interests and not its insured's interests.
But she knows, she can certainly subpoena Trivedi to trial, right? And get a statement of what happened, correct? And she has some personal knowledge herself because she was there and she said what she said. So I'm not exactly following the prejudice completely.
Well, the prejudice, the case law does say when an insured loses his or her ability to control the defense, that's prejudicial as a matter of law.
But the defense is still the same. The defense is a mistranscription. Your client knows that regardless of the deposition or not. Your client knows that.
Well, there's a question of fact. So to my client, it would
There's
matter.
always going to be a question of fact. So I'm not sure how it fits in the rubric.
Well, I would put it this way, that we have an insurance company as a movement for summary judgment, and so to the extent that there are factual issues, they shouldn't be construed against my client, but she certainly would like to be able to take a deposition of Trivedi, maybe establish that she never said anything defamatory, and have this settled now as opposed to having to go to trial in the Bronx.
Okay, thank you.
Thank you.
We'll hear rebuttal.
Quickly, Your Honors, I just wanted to reinforce that.
Question, what's your response to the argument that if it's an exclusion, as opposed to lack of coverage in the first instance, there has to be a specific disclaimer initially, or it's waived?
Right. That's an incorrect statement of law with regard to non-bodily injury claims like this one. The rule that counsel is referring to, I believe, is under, and Your Honor, is under Insurance Law 3420, which 20D, which applies only to bodily injury claims.
Your argument is that provision is inapplicable in its entirety because it's not a bodily injury.
Exactly, Your Honor. The only rules that apply in that sense are the common law rules of waiver and estoppel, and the case law is very clear. We've cited in the briefs that waiver does not apply to a failure to mention an exclusion. With regard to estoppel, it is potentially available, but only if the insurer fails to promptly reserve its rights. Here, Wesco clearly did. The fact that it didn't mention in that letter specifically the defamation exclusion doesn't mean they still mentioned all the other defenses, which apply to, just as the defamation exclusion applies to all the claims. The bottom line being that letter, by raising all of those coverage defenses, put the insureds on notice that a judgment would likely not be covered under the policy. That gave them the right to choose their own counsel from the beginning. There was no need to wait for Wesco to file this suit. They knew from the letter that Wesco was reserving its rights to assert coverage defenses. That in and of itself entitled them to choose their own counsel. They opted not to. They opted to take the free defense offered by Wesco. They made no complaints about their being jointly defended until years later, at which time the motion to dismiss was partially granted and partially denied.
Could you at least respond to your adversary's argument that with respect to the reservation of rights about the insured versus insured, that because you knew all the facts at the time the reservation letter was issued, you can't years later rely on that reservation?
Yeah, there's no case law supporting that. As long as the insurer identifies coverage defenses, that in and of itself, whether or not the insurer could have declined a defense at that point is irrelevant. There is no case law supporting the idea that just because Wesco went above and beyond by offering a defense, they cannot be penalized by that fact. In fact, they provided, rather than prejudicing the defendants, they actually provided a benefit by providing them with free counsel for all these years. By notifying them of the coverage defenses from the beginning, the insureds could have opted out of that. They could have chosen to choose their own counsel, but they failed to do that. Under the well-settled case law, that precludes the finding of estoppel.
Okay. Thank you. Thank you both. The next case for argument is Flores against 215 East 68th Street. You can proceed.
Courtney Swartz for defendants appellants, who I will refer to collectively going forward as the Rudin defendants. May it please the court. The issue on appeal before this court is that the lower court erred in its decision on all of the underlying motions for summary judgment, and it is submitted to this court that the lower court's decision is inherently inconsistent. The lower court found that there was an issue of fact as to whether the elevator misleveled, and if it did, to what extent. Therefore, to the extent it's found that the elevator misleveled and that the misleveling was impermissible and therefore dangerous and defective, It is submitted that that is solely the responsibility of Otis. Otis was retained by contract by the Rudin
Well,
defendants.
isn't there, go ahead, go ahead.
I was saying, if the misleveling was caused by operator error, why would that necessarily be the responsibility of the elevator maintenance company?
Well, there is no issue of fact that it was not caused by operator error. In fact, all experts opined and agreed, both that Mr. Velez, the individual who was operating the elevator, that he did not do anything impermissible, nor could he have done something that could impact the leveling of the car itself.
But didn't they opine that there was absolutely nothing wrong with the elevator that would cause it to mislevel? Didn't both experts opine to that?
Both experts opined that the elevator could not have misleveled more than half an inch, but they did not state with certainty, nor could they, that the elevator did not mislevel at all. Therefore, to the extent it did mislevel, to any extent, it was due to Otis's failure to maintain the elevator.
Otis was present at the location approximately 8 days before this incident.
That is correct.
How does that factor into your argument? Their presence, were they maintaining a misleveling issue, or was it something else?
It's my understanding that they were that they reset an off switch, a governor switch, something that has to do with the reset speed of the elevator. But even if that wouldn't impact the leveling of the elevator itself, that goes directly to notice. And notice that was only to Otis and not to the Rudin defendants. The Rudin defendants never entered the elevator machine room, which is where the parts and equipment for the elevator are located. They never inspected those parts, nor would they have, because they contracted out that responsibility to Otis.
Is that issue before us? I'm confused, because I thought that the appeal we have before us is the appeal by Otis. But is there an appeal by the Rudin defendants of the ruling against them vis-a-vis the plaintiff?
There's only an appeal by the Rudin defendants before this court.
But it's an appeal by vis-a-vis the Otis defendants, not vis-a-vis the plaintiff.
I'm sorry?
It's on the cross claims.
That's correct.
It's not on the main claim.
That's correct, the cross
The
claims.
arguments you're making on this appeal are not about whether or not your client is responsible or not for causing the accident. That's not before us. Is that correct?
Sure, but the issue then becomes whether or not the indemnification provision in the contract with Otis is triggered, and also whether or not Otis was negligent in its maintenance and inspection.
So you say everybody, or you and Otis, the experts agree that it wasn't due to the operator's error. Can you tell me where in the record Otis concedes that point?
Well, their expert opined that, or really speculated that the elevator could not have misleveled more than half an inch, but
He said it didn't mislevel at all. He didn't offer an opinion about if it misleveled, who was responsible or what was responsible. The position of Otis is that it did not mislevel to a dangerous level, right?
Yes,
It
but
didn't happen.
But the lower court found an issue of fact whether
So
or
isn't
not.
that the end of the day? We all go to trial. Thank you very much. I mean, doesn't that mean that we all go to trial on everything? I mean, how can we piece out the rest of this?
Correct, but then it was error for the lower court to then dismiss Otis out of the case on that basis.
That's a different issue than the further issue that you're saying is that your client was entitled to summary judgment.
Yes, summary judgment on its cross claims for common law and contractual indemnification
Well, how
against
could you get
Otis.
that if we don't know what happened?
Well, but if a jury would then find that the elevator did mislevel, it necessarily was due to Otis's negligence under theory of raising.
That's what I don't understand. I don't understand the second part of your sentence, which is if the jury found misleveling, that it then follows as a matter of law that it's due to Otis. I didn't see that in this record, and that's what I'm asking you for. Where did Otis concede that if there is a misleveling, it was mechanical and not operator?
Because Otis's expert and Otis's witness both stated that the selector device and the selector tape controls the leveling of the car, and they conceded that they were maintaining it on a regular basis. There were also
And
prior
can you
instances.
tell me where they say it could not have been due to operator error?
That's in Mr. McPartland's affidavit, and also Mr. Miller testified to that, and I believe that's page 9 of 43.
Thank you.
I'm not
Okay,
certain.
let's hear from your opposing counsel. No. You're the main person here. You come. I don't even know, the plaintiff put in a brief, but in fact, they didn't appeal anything. They're not an appellant. They're responding. Just like you.
Problem. I apologize.
No. Okay, go ahead.
Okay. Good afternoon, Your Honors. I'm counsel for Otis Elevator Company, defendant respondents in this matter. My name is Katrina Christofferson.
So answer my question. Did you, in this motion or anywhere on this record, concede that if there was a dangerous misleveling, meaning that it exceeded that threshold amount, that it was due to a mechanical problem and not an operator problem?
Sure. So I would first state that it's actually an impossibility for this elevator to mislevel by the amount claimed. But second of all, I would just note that the operator of the elevator controls the opening and closing of the door. They do not control the leveling, which is something that is stated in both expert affidavits. So it's not an issue whether or not Rudin caused the elevator to mislevel. The issue would be whether Rudin was aware of a mislevel and did not notify Otis. Given that the records show no notice to Otis, that's where, Rudin stays in the case and Otis gets out. Otis has established prima facie its entitlement, to summary judgment.
Well, if you service the elevator, isn't there either an issue of constructive notice or res ipsa loquitur, which if it applied would do away with, that's the doctrine that does away with notice.
Sure. Typically, I believe in elevator mislevel cases, res ipsa is not automatically applied. It may be in door strike cases.
It is actually routinely applied.
No, I said not automatically. I apologize.
Not automatically, but routinely.
But given that this is an elevator mislevel case and there's something called the run-by clearance, where an elevator has a 1/2 inch differential between the floor and the elevator, it's possible for customers to stub their toes and trip and fall and have nothing to do with the elevator's leveling.
And on October 17, 2017, Otis was out there for another issue, but it wasn't anything related to misleveling, right?
That's correct, Your Honor. It was due to a governor safety switch, which is typically relating to the load on the elevator, like the number of people in an elevator, or nothing to do with the selector device, which is the leveling component. If there are no further questions, I would just rest on my brief at this time.
Any questions, Counselor, colleagues? Thank you.
Thank you.
Plaintiff?
Good afternoon, Your Honors. Marielle Crippen for plaintiff appellant, the respondent here.
Not an appellant.
No, I'm respondent here.
That's a head scratcher to some of us here, but you're not an appellant.
Yes, we did not cross appeal on this brief, but at the same time, our brief states that the lower court should have denied Otis's motion for summary judgment dismissing plaintiff's complaint.
But given that you didn't cross appeal, does that affect the range of what we can do?
Well, there is case law that in rare circumstances, it does say rare, but in certain circumstances where the issues are so inextricably intertwined as they are
What's
here.
rare about this case, though, in the absence of an appeal from you, why should we be addressing those issues in a vacuum?
Well, it's also in their appeal as well. The appellant actually does move to reinstate plaintiff's complaint as against Otis, as well as their cross claims. They state that the granting of summary judgment to Otis.
But don't both defendants make a prima facie showing that there was nothing wrong with the elevator? Both their experts opine that the elevator did not mislevel inappropriately. There was nothing wrong with it, and it was operating perfectly, and it was serviced perfectly. So wasn't the burden then on you to come up with an issue of fact as to their being aware that there was a problem with the elevator?
Well, the court did find there was an issue of fact as to whether the elevator misleveled and if that misleveling was a dangerous
some level
condition.
of misleveling is basically normal, according to the defendants, that it's not a perfectly level elevator. As long as it's within certain parameters, there's nothing inappropriate about that.
Well, they cite to a certain regulation that it's permitted up to a half an inch, but that regulation they both concede does not actually apply to this particular elevator because it predates the imposition of that particular regulation. So it is actually even questionable whether a half an inch would be permissible
So why
as
did you
well.
appeal? Why isn't there an appeal by the plaintiff? Of course.
I don't have an answer to that question, Your Honors, as to why we did not cross-appeal on this, because there is a question of fact. Otis did have notice. They did repair something related to the leveling mechanism December 2016. The court says in their order that's too far before, but that's less than a year before the accident.
So the way that this would work, I mean, essentially, based upon the relief, is that you couldn't go against Otis, but if we reverse, then I suppose Rudin could seek contribution or indemnification from Otis, and that case would be proved there. I have to admit, I'm scratching my head procedurally on what's going to happen here at a trial. Who's going to go against who, and whose burden is it to prove what?
Procedurally, I mean, under some of the case law, like Gottlieb v. Gottlieb and Sintalta v. Caristo, that you can grant relief to a non-appealing party based on these particular issues that are so inextricably intertwined.
But didn't you chart your own course? Why would we save you from what you decided to do? I mean, this wasn't something that was rare or you couldn't figure it out what your rights were.
Just under the facts of these particular circumstances, the complaint should be reinstated against Otis, and if the cross-claims survive against Otis, they're a proper party to this case. The court only granted their motion on notice. It wasn't whether, they found a question of fact, whether there was a defective condition.
Okay.
It was only on notice, and I would submit that there was notice here.
Okay, thank you.
Your Honors.
All right, we'll hear rebuttal.
I have to say, I'm still confused too. If plaintiff's not appealing on this, and your expert put in an affidavit, there's nothing wrong with the elevator, and Otis put in an affidavit, there was nothing wrong with the elevator, and it was properly serviced, then what's the basis, without an appeal by plaintiff, to create an issue of fact about them having notice of anything being wrong with the elevator?
Well, there was differing testimony and evidence as far as to what extent the elevator misleveled. I believe plaintiff testified.
But didn't you, defendant Rudin, testify and put in an expert testifying that there was nothing wrong with the elevator?
Yes, but more importantly, that our elevator operator did not and could not have done anything to cause the elevator to
Didn't your expert also say there was nothing wrong with the elevator?
Sure, but he also inspected the elevator sometime after the accident, and also I would note
He didn't
after.
put forth any evidence that there was anything wrong with the elevator, though. Your expert did not opine there was anything wrong with the elevator.
Correct, but the lower
Where's
court.
the evidence? I know you're saying the lower court, but where's the evidence in the record that there was something wrong with the elevator and that Otis had noticed that there was something wrong with the elevator?
Otis's own repair logs, and in fact, the one specifically manufactured after Otis's repairman responded to and performed testing to the subject elevator immediately after the accident, indicates that it misleveled 3 to 4 inches. So their own repairman claimed that the elevator misleveled more than half an inch. 3 to 4.
Is that in the record? Because I thought the testimony was that that there was nothing wrong with the elevator and it was operated properly. So where is in the record does it say about they're acknowledging that it misleveled 5 inches? What's the page?
That would be, if you look at the elevator logs, and actually if you look at Mr. Miller's testimony, page 835 of the record, page 905.
And if you're right, then what's the procedural posture of this case? What's going to be tried?
I'm sorry, I didn't hear that.
I'm trying to understand. So what would be tried here?
Well, so the lower court found an issue of fact and actually said that it's up to a jury to decide whether the elevator misleveled. So in the event a jury chooses to, and this is actually sort of a quoting of the lower court's decision, but if the jury believes plaintiff's version that the elevator misleveled 5 inches, It's clearly due to Otis's negligence, its failure to maintain the elevator.
Otis is out of the, who does she recover again?
Well, that's why Otis should be brought back into the case.
But she didn't appeal.
But I appealed the dismissal of my cross claim, so at the very least.
You'd have the burden on the cross claims, right?
Correct, and
If
I'm
you're right, then the cross claims exist, then you would have to prove that there was an improper or dangerous condition with the elevator? You'd prove that? I mean, wouldn't that be your burden of proof?
I wouldn't, in other words, if the jury found that to be the case, then the indemnification provision is triggered.
Whose obligation is it to prove? All right. I thank you. I think I'll try and straighten out my confusion by looking at your papers again. Thank you.
Thank you.
People versus Mabel. You can proceed.
Good afternoon, Your Honors. Nathan Brown with the Legal Aid Society on behalf of the appellant Andrew Mabel. It's a pleasure to be appearing before this court for the first time. Mr. Mabel's sentence was excessive in light of his minor role in the offense and should be reduced.
What minor role? Was he not the person who dragged the individual out of the vehicle?
That was his role in the offense, Your Honor, but it was one of the other individuals who threatened the complainant by placing an object in his side, demanded that he turn over everything he had, including his iPhone and his money, to delete his iCloud. After Mr. Mabel removed the complainant from his car.
If the victim hadn't been removed from the automobile, there would have been no carjacking. So doesn't that make his role central?
His role is certainly a part of the offense. It would have been a different offense, sure, but his role in the overall offense, considering the entirety of what did occur, was minor. That's our position. In addition to his minor role, they left him behind. I think highlighting the role that he played, being comparatively minor, when he was arrested, he identified the two other individuals and indicated that one of them hit him during the course of the offense. And so I think that there is every indication that he didn't take part in the planning of this offense and certainly was involved to the extent that he was involved, but it was comparatively minor. Mr. Mabel was also stabilizing his life while he was out on post-release supervision. He was working in a maintenance job during the 6 months that he was out. Was on track to get a full-time position. He was dutifully complying or reporting to his parole. It's notable that he was homeless during this time, but has no, notwithstanding the offense that we're here for, he has no other arrests for turnstile jumping, petty larceny, nothing like that.
Can you point out to what defects there were with the waiver of right to appeal?
Certainly. The court's waiver was defective for several reasons. First, the court engaged in several confusing and misleading statements, including several rapid-fire and/or statements that gave the impression that only errors and the excessiveness of the sentence can be appealed. The court never explained any rights that would survive the appeal, and given other statements about finality, gave the impression that it was an absolute bar to the appeal. And the court failed to distinguish the rights that were being forfeited by the plea itself from the rights.
To the extent that there were any deficiencies in the court's colloquy, weren't those deficiencies remedied by the written waiver, which the court elicited from the defendant, that he had read and fully understood?
They weren't cured, Your Honor. The written waiver is no silver bullet, and this court has recognized that the court still has an obligation beyond the defense counsel's explanation of a written waiver to the defendant. And a written waiver generally will need to harmonize with the oral colloquy, and when it conflicts, such as it does here, it shouldn't be used to cure the deficiencies. So, for example, the court indicating there was a final bar and that no issues survived is in conflict with the written waiver. One other point I'd like to make is that I mentioned that Mr. Mabel identified the two other individuals who were the more significant actors in this offense. They were never apprehended, and so highlighting the excessiveness of his sentence, the two other men received no consequences for their role in the offense, and yet Mr. Mabel, for his minimal role, received a maximum sentence that he was possible under the circumstances. If there's no other questions, I'll reserve for rebuttal. Thank you.
Colleagues? Thank you.
Good afternoon, and may it please the court. My name is ADA Levi Stoke for the People, prosecutor in the Bronx DA's office. The defendant here was one of the central actors in a violent carjacking. He was the principal who was seated in the front passenger seat. One of his partners in crime puts an object in the driver, our victim's side, and they say, "Give me everything in your pockets," and they say, "Wipe your iCloud," in furtherance of taking his phone. Those are the verbal statements. Next comes the physical action. That's what our defendant here provides. He takes the victim and he rips him out of the car. And then the other unapprehended individuals take that car. He's arrested. There's a felony complaint drafted, 2 counts of robbery in the 2nd degree. And then, after plea negotiations, a Supreme Court information is drafted for robbery in the 3rd. The defendant here faced 15 years maximum for a violent felony offense. After bargaining, we came down to 3.5 to 7 years. Defense has said that this is the maximum punishment. It is the maximum punishment on a Supreme Court information, but it's not the maximum punishment on what was on the original felony complaint. If we chose to, we could have gone to the grand jury, we could have secured an indictment.
Right, so the consideration here was that he was in charge of the violent felonies in the Superior Court information.
The robbery in the 3rd degree would not have been.
Right, it wasn't.
Pardon me, Your Honor?
So that's the consideration that he got in exchange for his plea.
Correct, Your Honor, yes. And then, after this plea was taken, now he appeals the case here, saying that this is excessive. It's not excessive. He faced a maximum of 15. Considering his background as well, we ask this court here not to lower his punishment at all. It is not excessive, and unless this court has any questions for me, I would just ask that you affirm.
Can you address the waiver?
The waiver, both the oral and the written portion, there was no error found, I believe, in any.
Any further questions? Okay, we'll hear from your adversary on rebuttal.
Thank you.
I'll just quickly note that it's certainly not the case that there were no errors in the appeal waiver, as I discussed earlier. And then I think, from my perspective, it's pure speculation that he faced a sentence on higher charges. There's nothing in the record to indicate that the prosecution could have met their burden on those charges, was planning on meeting their burden on those charges. We could equally...
Well, counsel, well, that may be true. The consideration is that those higher charges were not brought, right?
They were not brought.
So that's consideration, isn't it?
If it was likely that those charges could have been brought, I think that's where the speculation for me is, that we don't know why the prosecution settled on robbery 3. Certainly there were other higher...
Don't you think it was as a result of plea negotiations?
But we don't know the content of those plea negotiations.
But clearly they would have been favorable because your client got the benefit of the bargain with the nonviolent felony.
Or, again, speculating, he suffered a harsher penalty than the lower charges that were in the complaint. We just don't have the information to be able to say that he could have been convicted on those higher charges.
So is it your position that whenever a person pleads guilty to a Superior Court information, which by practice they only charge what the person agrees to plead guilty to, that there's never consideration and the waiver of right to appeal is ineffective?
No, of course not. I'm saying that we don't have the information available to us in the record to determine which charges were the ones that were, likely to be proven at trial, such that he was...
So is your suggestion that that's what we have to engage in an analysis of what the grand jury would have brought back an indictment on?
No, I'm saying that the argument by my adversary is solely speculative, that the 15 years that he did face theoretically make the sentence that he received, quote, lenient, as they say in their brief. Thank you.
Thank you. Alpine Custom versus Urcism. You can proceed.
Good afternoon, Your Honors. If it pleases the Court, Anthony Brigandi of Law Office of Phillips & Millman on behalf of the respondents. Your Honors, as you can see from our briefs, this is a very simple case. There was a home improvement contract that was between the homeowner, the respondent defendants, and a non-party contractor who was unlicensed in Rockland County. The general contractor then entered into an agreement with the subcontractor, who was also an affiliate associated with the general contractor, and based upon substantial delays.
You're basically saying the contractor was not licensed.
Correct.
The subcontractor never had any agreement with you.
Correct.
The subcontractor never submitted any affidavit.
Correct.
Showing they had any agreement with you, and therefore there's no basis for this claim.
That is correct, Your Honor. So that's our argument there. Regarding the motion for summary judgment, because he does bring up issues saying that the lower court didn't acknowledge that he had some kind of so-called license, but as cited in our brief, his license was limited up to $100,000. The scope of this work was substantially higher. I believe the value
You're
of
saying it doesn't matter because you didn't have an agreement with them anyway.
I'm sorry.
Doesn't matter because you're saying you didn't have an agreement with them anyway.
Correct, Your Honor. That is correct. And then the only other issue was the motion for summary judgment where he says it was too early, but he failed to present any evidence as you've seen. I'm not going to waste your time any further. It seems that you guys fully understand that this is a simple issue and all of the issues there. Thank you.
Thank you.
Thank you.
Cohen versus Cohen? No, yeah. Cohen versus Cohen. You can proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Benjamin Littman from Elman Freeburg, and I'm here on behalf of the plaintiff appellant, Matthew Cohen. Your Honors, the very two things that the Supreme Court impermissibly ignored, Matthew's actual allegations and the actual law that governs them, make this a simple case for across-the-board reversal. Indeed, in Matthew's amended verified complaint, he pleads a straightforward, classic case of fraud and conspiracy against the co-conspirator defendants. And he does so.
Well, let's leave the conspiracy out of it because you don't get to conspiracy unless you establish the fraud. And the lower court said there were two bases on which you didn't establish fraud, why that had to be dismissed. One was your lack of particularity. You know, you said there were misrepresentations, but we don't have times or dates or things that were said. I think probably even, well, I don't want to say more significantly, but another serious issue she raised is the absence of any justifiable reliance that you believe the misrepresentations that were being made or that your client believed them. So let's address that first.
Yes, Your Honor.
Before we get to conspiracy.
Yes, I'm happy to address both issues in turn. With respect to the first, there is no dispute that A, Matthew pled all of the elements that he was required to plead as to fraud, and as to the sufficiency of the allegations.
Well, there's some dispute, or otherwise we wouldn't be here. So tell me what he pled. Why did he satisfy particularity?
Yes,
There's any dispute that in fraud you have to have particularity, right? That's 3016. Thank you very much, right?
The issue that is raised.
Okay, so now where's the particularity?
Yes,
Go
so the
ahead.
particularity is rife in the complaint, and there are numerous misrepresentations of both present and past fact, as well as false promises of future
Well, those are
intent with respect.
conclusions. Again, the conclusions. I'm giving you the opportunity to put forth your best case. Go ahead, tell me, facts.
Sure. So if your honors look at paragraphs 58 through 62 of the complaint, this is the amended verified complaint, there are specific references to specific dates, to specific language, and to specific places. Again, none of which is required. All that's required is that there be allegations giving rise to a reasonable inference of the alleged misconduct.
But they have
looking
to
at
be
the-
facts.
looking
No, you
at-
keep saying that, but it's got to be more than conclusions, right?
Oh, absolutely. We-
Okay.
Yes,
All right,
so
but
it-
you're
it-
saying these are the paragraphs.
Yes, paragraph 58, we allege that in mid-March of 2017, while Matthew and Courtney were vacationing at the Yellowstone Club in Montana, very specific as to time and to place, that he saw a text on her phone and confronted her about it. And she denied that there was anything untoward about it. After that, there are allegations continuing in the additional paragraphs I mentioned through 62, when Matthew then speaks with Courtney's mother, whom Courtney had directed to make similar misrepresentations about the fact that they had never been involved in an affair, and that all he had to do was cause the reissuance of the shares for her to stay in the marriage as a faithful spouse. Now, again, that continues throughout the summer of 2017, and these are paragraphs 64 through 75, where there are additional times in which Courtney repeats that she was not involved in an affair with Icus when Matthew confronted her with suspicions that he had. And then again in the fall, when the lawyers for both sides are specifically discussing the reissuance, we allege again that in October and November of 2017, and these are paragraphs 77 through 77 and 78, that in October and November, again, Courtney and her mother both made specific misrepresentations about past fact regarding her affair with Icus, as well as future intent regarding her intent to remain faithful going forward.
Well, just going to say we're running out of time, and
Yes.
you didn't say more serious, but I would say what's arguably the more serious problem is the justifiable reliance, because the amended complaint specifically says she refused to talk to him, she refused to be intimate, she was away from home all the time, there was a subjective test. I mean, there were so many indications that he believed she was having an affair, so how could he justify, isn't it incredible that he justifiably relied on her representation that she wasn't? In addition to all that, he refused to sign the modification, obviously believing that that was needed to make it operative, his transfer of the shares. All those things strongly suggest that there was no reliance whatsoever on any allegation by her that she did not, that he did not believe she was having an affair.
May I address that briefly? I see that my time is up. So frankly, this is an even easier issue for reversal. Again, it is clear that as a general matter, as the respondents concede, justifiable reliance is an issue of fact for trial. That is
Not
even true.
always, though. Not always.
Absolutely not always, but it is
Not
even
if it's
truer.
incredible.
It is even truer in the context of relationships between family members.
But that's when family members are doing business together. I mean, what is the difference here? But you're saying it's justifiable reliance, but isn't it just really willful ignorance?
Not at all. There was no proof at the time. Again, we have to look at it at the time, not in hindsight. Obviously, in hindsight,
Well,
we have all of this additional information.
There was certainly proof. There were text messages that he was looking at. He had detectives watching her, so.
There wasn't proof at the time. There were text messages, which he then confronted her about, and she then denied. With respect to the private investigator evidence, that came to light, as we allege, in early May of 2018.
This is clearly not a relationship where they're happily married, everything's peachy keen. Clearly, he's really concerned that something is going on. It's not like those cases you cited, like the Epiphany Nursery School, where the wife clearly relied on the husband, he was a trusted confidant, providing advice. That was not the situation. There's no way comparable.
I think what's interesting, and I'm glad Your Honor raised Epiphany. So we had mentioned Epiphany in our brief as a case that makes this an easy one for reversal, in the sense that there were two spouses involved. The other case we cite, which is in this case law that this court has propounded regarding reasonable reliance in the context of family relationships, which is the Braddock case, is arguably even more on point, because there was a relationship between cousins, and they were involved in a business deal, and the cousin who brought the fraud claim had already been duped. And then he relied in turn on new assurances from his cousin, and the court said that the cousin who had been duped was entitled to reasonably rely, or at least to get past the motion to dismiss, because the cousin who made the misrepresentations had an obligation to act in good faith. And that applies even more so here when we're talking about spouses.
Is it your position that in cases such as these where one spouse is suspected of having an affair, but they constantly say, no, 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 there's no affair, it's going to be all good. And if it turns out to not be all good, then that is fraud?
Not at all. Again, we have a very specific context here, and this goes back to the sufficiency point that we started with. Again, there were misrepresentations regarding past fact in terms of fidelity and future promises regarding fidelity. Those were the same misrepresentations that were made over and over again, and to your question, Justice Pitt, they were made in the very specific context of causing Matthew to reissue the shares in his multi-million-dollar Park Avenue apartment in the parties' joint names.
Isn't it true that the husband here just reissued the share in the hopes of saving his marriage, irrespective of whether she was cheating or not?
The allegation is that we have multiple misrepresentations that induced Matthew to cause the reissuance of the shares. We have pled every element, and we believe we have pled so more than sufficiently to carry a motion to dismiss and to proceed to discovery. Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court, Jason Advocate for the respondent, Courtney Cohen, in this case.
Counsel, can you respond to your adversaries pointing out of paragraphs 58 to 62, 64 to 75, and 77 to 78?
Well, I was going to hit the justifiable reliance first. I'm going to hit that issue first then, okay, Your Honor? On those issues, what he is trying to do with this case is to make it about the alleged infidelity. But that is not the actual fraud case here. The actual fraud case is about a fraudulent misrepresentation. That fraudulent misrepresentation is that the wife here said to the husband at some point, we don't know when, we don't know where, we don't know who else was present, we don't know whether it's one conversation or many, but that he said to him, she said, I will be faithful and a loyal and faithful wife to you if you transfer the shares to me. That's the nature of the fraud. All these allegations about whether she was or was not having an affair for a month, a year, 20 years before, it's irrelevant to the fraud claim, which was a simple fraudulent misrepresentation case. But we don't have the details for that. To defend yourself on a claim of fraud, you need to know where that occurred. You need to know. We don't know if it occurred in the summer of 2017 or the summer of 2016. She might have been in Florida with her father. We don't know where she might be, and she could say, I wasn't present. But when you don't have the allegations pled particularly enough, then she has no ability to respond to that. And what are those words used? Is this a quote? Is she alleged to have quoted from 18th century poetry here? This rings out of Shelley or Byron, that she was going to be a loyal and faithful wife. We don't know what that even meant in the context of this family. People take different meanings to that. We're in the 21st century. People sometimes have open marriages. They have different types of marriages. People stay married sometimes since they separated for 20 years, and they're still married.
That may be true, that it's subject to different interpretations, but we're dealing with a pleading motion now. How does that enter? And this is what he alleges, that she said she'd be a loyal and faithful wife.
Well, what does that mean, though? And is that the actual word? I don't know what that means, Your Honor. I'm sorry. In different contexts, it will mean different things. You know, did it mean she was going to stand by him? You know, as the famous song was, is she going to stand by him? Is that what she meant? Did she stand by him? Did it mean, in another place in the complaint, he said that the mother of the respondent here said that she would not leave him. She would stay in the marriage. And in fact, she did stay in the marriage. She didn't start this divorce case. He did.
Would discovery matter if this case was to survive this stage and proceed to discovery? Would that clear up some of these issues?
I don't think the discovery in this case is going to clear up anything. It's going to be a he said, she said, with the plaintiff saying, at some point in time, she said something to me, and the defendant saying, I don't recall ever saying that, or I didn't say it, or I don't know when I could have possibly even said it. And that's just, this is just on the particularity question, Your Honor.
I want you to address the reliance.
Because I'd like to as well, because the justifiable reliance is also, I think, a very strong point here. And what the appellant fails to, advise this court is that, and this is in the judge's decision, it was a 7-month process to get the shares transferred into joint names. Started in April, it ended up in November of 2017. In August of 2017, the appellant puts in his complaint that he went and checked surveillance tapes of the wife and found her that she had left a certain place at a time that she was not truthful about. So he knew at that point in time she wasn't being truthful about where her activities were occurring. And he suspected at that moment he knew she was having an affair. That was August. He could have at that moment stopped the transfers of shares. He could have done anything he wanted and just stopped it. But it's clear that he let it go ahead because he was attempting at this time to try to save the marriage by putting the apartment into joint names. And that was his intention, and that's what he acted on, and that's what ultimately occurred here. So I don't think there's any fraud.
Maybe that's true, maybe it's not. Again, does the procedural context of the motion being a motion to dismiss the pleadings present any impediment here?
If the actual complaint itself were to have not been so internally inconsistent with his own statements, it might have raised an issue of fact. But where he obviously states in his own complaint that he knew that she was, in his opinion, he knew that she was in fact still being not faithful to him, and yet she still proceeded with the transfer of the apartment, it makes any justifiable reliance simply impossible in that context. And I would also argue, although I don't have any case law on it, I believe that where a case is a bench
I'm going to ask you to finish.
Where it's a bench hearing as well, it's going to go to a judge. And this judge in this case that was before it already determined that this is simply not credible. Your Honor, thank you very much.
Without any testimony, but okay.
Thank you.
Yeah. All right, let's hear from the co-respondent. Go ahead.
Good afternoon, Your Honors. May it please the Court, my name is Peter Nisman, Law Office of Peter Nisman, here on behalf of the respondent, James Ickes, and I'm going to endeavor to be short and to the point in that the lower court properly dismissed the claim against respondent Ickes, which was the fifth cause of action based upon fraud alleged in appellant's amended verified complaint. To the point, allegations made against Mr. Ickes are vague, conclusory, base allegations at best, and thus insufficient to sustain a cause of action, whether that cause of action is for fraud, conspiracy to commit a fraud, or aiding and abetting a fraud. The actual amended verified complaint just said fraud in broad terms. And more to the point, there were no specific facts alleged or pled as to any agreement that it would be in Mr. Ickes' pecuniary interests for appellant not to learn of the alleged affair. There were no specific facts alleged that Ickes and respondent Courtney Cohen agreed that it was imperative that appellant not learn of the alleged affair before the reissuance of the co-op shares into joint names of the parties. And I think, in fact...
there were facts alleged that they had an affair. That in and of itself, is it your position that that in and of itself isn't going to support a cause of action against your client?
Absolutely, Your Honor. In fact, there were no allegations that Mr. Ickes was even aware that Ms. Cohen had a prenuptial agreement. There were no allegations that he was aware of Mr. Cohen's assets, or that there was a co-op, or that shares were going to be reissued, or that there was anything going on with any lawyers. Nothing at all. And in fact, in the verified complaint, there was no allegation made as to any agreement between Mr. Ickes and Ms. Cohen to the underlying tort, which would be the fraud. There would have to be, whether it's aiding, abetting, or conspiracy to commit a fraud, not only would the underlying tort of fraud have to survive, which I don't think it will, but beyond that, there would have to be some showing that Mr. Ickes was aware of the fraud, that he participated in an agreement regarding the underlying fraud with Ms. Cohen, and took some overt action in in moving forward with that fraud, none of which happened. There's no, you can't have a preponderance that, or assume that bare allegations that are set forth are truthful. There has to be something more. Otherwise,
I'm going to ask you to wrap up.
yeah, anybody can be brought into the case. Maybe he has a cause of action for an affair. I don't even think that would work out, but that's the best that he has.
I don't think
Thank
we
you.
have that anymore.
Not anymore.
All right. Okay. Rebuttal.
Thank you, Your Honors. Briefly, with respect to justifiable reliance, again, it's important to note not just the context in which the alleged misrepresentations are to have occurred. Again, between spouses, which is a partnership that the law looks on with special attention and with special surveillance, as Your Honor, Justice Gessmer noted in the KS versus ES case that we cited in footnote 2 in our reply brief. But again, Courtney continues to deny the affair. So we allege that she denied it at the time, and that we relied on those misrepresentations. And in fact, we allege that they were so convincing that we relied on them. And in fact, she's continued those under oath in the Supreme Court, as well as in her briefs before this court. Likewise, what's problematic with the Supreme Court's determination in light of that is that the Supreme Court decided necessarily that Courtney was lying and that she committed perjury, because again, she continued to deny the affair under oath.
Well, we don't know. We don't know one way or another right now.
What's that, Your Honor?
We don't know one way or the other if they had an affair yet. Nobody. I mean, part of it is the same thing I said to Mr. Nisman. I mean, good enough. Or to Mr. Advocate. There's been no testimony here.
That's exactly the point.
All right. So we should really couch these in terms of allegations, and all the way along the line, and it either makes it or it doesn't make it.
I think Your Honor is absolutely right. We allege there was an affair. They vehemently denied that there was an affair.
Let's go back.
That itself.
The trial or the case is not about whether or not she was having an affair. That does not state a cause of action to say someone's having an affair. It has to be tied into the other allegations in the complaint, and whether he reasonably relied on her claiming she didn't have an affair to do the actions she did. It's not enough to prove that she had an affair or to say there's an issue of fact about whether she had an affair.
Absolutely.
Which is what you seem to be arguing.
Absolutely, that's not enough. But that's not our claim. Our claim is that he relied on those and she made those misrepresentations to fraudulently induce him to cause the reissuance. Again, it's in a very specific context, and they can't claim surprise about what we're alleging here. There were meetings between the lawyers, there were discussions about the reissuance, and in that very context, which Courtney was well aware of, during the dates that we specified earlier, that's when these alleged misrepresentations are to have occurred. And regarding your point, Justice Gish, yes, you're right. We don't know whether she lied or not. We believe so. Or we believe there was an affair. They believe there was not. But that is precisely an issue of fact.
Counsel, but with regards to the justifiable reliance, isn't it true that even after all this, you're saying that he relied on her representations, that she wasn't cheating or whatever was going on, but yet the husband went on to hire a private investigator afterwards? Doesn't that belie then his justifiable reliance argument?
Again, the timing is important here, Your Honor. The private investigator was hired after the reissuance had already been effectuated. The reissuance, as opposing counsel mentioned,
Well,
was...
what about what Mr. Advocate said about the surveillance of her comings and going into the apartment that he had, and that he clearly was or that he alleges he looked at?
Yes, Your Honor.
Because that's in your complaint.
It is, and that is the only instance of contemporaneous surveillance that we have. And let's look at what that actually says. And these are, this is late July and early August of 2017, specifically paragraphs 73 through 75 of the complaint. And Matthew was on vacation or on a business trip in Miami. He comes back to the apartment. He checks the surveillance videos, and he sees that on the night of the 27th, Courtney left the apartment late, and then she returned the next morning wearing different clothes. She wasn't with anybody. She wasn't with Icus. That's it. He then confronted her.
Before the shares were transferred.
That's correct, but he confronted her about it. She spoke to her mother, and she and her mother both then told Matthew that, in fact, she had been with friends watching Netflix out. And again, the question is not whether she was lying or not. The question is whether we have pled that Matthew justifiably relied on his wife's misrepresentations. And again, in the specific context of a spousal relationship, if you can't rely on your wife whom you have kids with and whom you want to maintain your marriage with, then when can you reasonably rely? And finally, with respect to conspiracy, just very briefly, there's nothing conclusory about our allegations. Again, that's only true if you ignore what we actually allege. I'm not going to go through everything that we cited in our briefs. But again, we both explicitly allege all of the connector elements of a civil conspiracy, and we allege the basis that gives rise to those connector elements, which are the agreement to keep the affair secret based on all of the extreme measures they undertook to do so. We allege that there was also an agreement that it would be in the pecuniary interest of ICUS to do so, precisely because Courtney intended to remain with ICUS after leaving Matthew, and that she had already been funneling money that she had access to from Matthew to ICUS. So it is eminently reasonable to infer, and we're obviously entitled to every reasonable inference, that therefore ICUS was a co-conspirator, he had a stake in the affair, and that they had an agreement that it was in his pecuniary interest to go ahead with this scheme. And again, the discovery might well show additional facts regarding the agreement and additional facts regarding intent, but right now, we have alleged more than sufficient evidence to get past the motion to dismiss and proceed to discovery. That's the teaching of Cohen brothers, and that should be the outcome in this case. Thank you very much, Your Honors.
Thank you. Thank you all. Darby Scott versus Libach. You can proceed.
Good afternoon, Your Honors. May it please the Court, my name is Robert O'Hare on behalf of the appellant here this afternoon. This is a case of accounting malpractice that was dismissed in part by the lower court based on the statute of limitations.
Counsel, the October 2003 engagement letter specifically indicated that the fee assumes adequacy of records, internal controls, and cooperation and assistance of your accounting personnel. And then when plaintiff testified, she basically conceded that the accounting firm never really handled inventory and things of that nature. And she testified that she was aware of minor invoice issues, and her general counsel also indicated that she was not really aware of how QuickBooks and other information, how it was unaccounted for. How do we reconcile that? How is that accounting malpractice when they specifically disclaimed any, I guess, I don't want to say negligence, but they based it based upon adequate records that they never received?
Well, Justice Pitt, I think you're referring to language in the engagement letter that states as follows. And it's in both engagement letters. They're in the record at 113 through 116, I believe. And the language that you're referring to is our fee assumes adequacy of records, internal controls, and cooperation and assistance of your accounting personnel. That's the language that you're referring to.
Yes, that's what I just read.
Right. And when Mr. Liebach testified at his deposition about what he meant by that, he testified that that was referring to the initial documentation that they were receiving. And the reason why this is in here in this engagement letter is the way they set the hourly fee. It was $400 in the first engagement letter. I think it was $600 in the second engagement letter. And so that language that you're referring to is only to take into account if there were some problems initially with respect to the records that were being provided to Liebach accountants in starting up the engagement, then that fee could be revisited. It has nothing to do with subsequent records down the road that would have been provided to the accounting firm as part of its daily activities. And in fact, it says in here that it makes a reference to assistance of your accounting personnel, and that goes to our statements that we've made on this appeal, that they were the de facto accounting department of the plaintiff in the case. There were no accounting personnel. The only accounting personnel that was ever on premises, that was ever working on anything having to do with the account was the defendant's accounting personnel. In fact, they go so far, if you look at references in the respondent's brief, they keep referring to our employees as the production team, or her employees as it relates to production and sending out different products and things like that, and packaging and taking in inventory. But there's never a reference to any accounting personnel about which or on which the defendants could rely.
So I just want to understand your claim, right? The engagement letters don't say anything about inventory or inventory control systems, does it?
They don't specifically, Your
So
Honor.
is it your, two things. Is it your position that the engagement letters, to the extent that they refer to bookkeeping and administrative services, that incorporates inventory control services as well?
We do, Your Honor, and that is because if you look at the language there, it's not limiting, right? So it says bookkeeping and administrative tasks, and then it says which includes but is not limited to, and then there's a laundry list of items. And as
so anything related to accounting, you think comes within the rubric of those engagement letters? Then? I mean, if you're right about how we have to look at that, then it would be clearly everything that an accountant can do.
well, it's only everything that the accountant did in this case, right?
Well, no. I'm trying to understand the language. You know, because, in other words, it doesn't say audits. Does the including but not limited to mean audits in that agreement?
Well, it would depend on, again, what the accounting firm undertook as part of its responsibilities. And it's basic tort law that when someone assumes a responsibility, they have an obligation to carry it out reasonably.
I'm asking you about what does the agreement encompass? If the duty comes from the agreement, then I get that. If the duty comes from the general duty under accounting principles, which you seem to argue as well, then that's something else. So I just want to really understand your theory of the case.
Right. Well, I think you've made a good point, Your Honor. There's two things. There are two things upon which we're relying as it relates to the inventory or the work with respect to inventory. The first is the engagement letter, and we say that's not limiting. If anything, there's a question of fact on that, and there's a dispute as to what the language means in the letter, right? And there's different testimony as to what was said at the time that this was entered into, and there's extensive testimony that we cited in both of our briefs before this court, setting forth what Ms. Darby Scott was expecting of her accounting firm when she hired them as it relates to inventory and other controls. There's also what our expert has said in his affidavit.
I'm going to let you finish that part of the argument. We understand this is a somewhat complex case, and I do want to reassure both parties that we have your briefs and we are really familiar with the issues. So don't be concerned that this argument may be somewhat abbreviated.
Okay. So thank you, Your Honor. If I could just finish that point on what the expert has set forth. So not only is the engagement letter—
When you say the expert, who are you referring to?
We're referring to the expert, the partner at Alex Partners, Mr. Jenkins. And
Now, he's the one who didn't do any independent analysis, but he relied on the analysis done by Ms. Mayo, who had no accounting background at all, correct?
Well, and that's incorrect, Your Honor, respectfully. And the lower court missed that, and the respondents do not touch that in their briefing. Alex Partners was originally hired to conduct an investigation into the facts and circumstances of the malpractice. They did their own independent work with respect to the issues that are relevant in the case. And Mr. Jenkins relied on those and set forth the various issues that were identified with respect to those things. And so it wasn't just his reliance on the work product that Ms. Mayo had done, but it was
Didn't he rely on her work product in part?
Well, what he said with respect to her work product, he said, he gives an example of what is supposed to be done in terms of the analysis and what he would do in terms of conducting a similar analysis. And then he points out, this is what Ms. Mayo did, which lines up with what
But
he
did
was
he
saying.
rely on her work product in part?
I think he relied on her methodology. That's what he relied on, Your Honor. But separately, he relies on the work of his own firm, which he points out, and if I may.
How could he rely on her methodology without relying on what she did with the methodology?
Well, I think, Your Honor, he doesn't drill down into the numbers, right? So that's left for another day. And what is permissible with respect to experts is, one, are the facts and circumstances on which they are rendering their opinion things that are typically relied on an expert in the field? Well, one he relies on is his own firm's work product. That is clear. He says with respect to those issues, there was no supporting documentation for credits, payments were misimplied, and in some cases, there were no records with respect to payments. All of those things, by the way, Your Honor, go to inventory issues, because if there's those red flags, and if, as the accountants had in this case, an obligation to bring that to the attention under the IACPA standards to their client, she would have been alerted to the fact that there were issues like she was at the August of 2010.
Just to wrap that up, so that I understand. So your position is that under the accounting standards, that this expert is at least raises an issue of fact about whether the incomplete documentation that they obtained would have raised red flags about inventory mismanagement, I don't know what else to call it, and their duty would have been to bring it to her attention?
Yes, absolutely.
But not necessarily to put in the controls themselves.
Well, we point to record evidence where she was expecting that there were bills concerning putting in place a perpetual inventory system, which...
But that only happened after the statute of limitations
No, Your Honor.
I mean, aren't those are the things that you're relying on in order to have continuous representation?
Well,
and I suppose for me, the two are tied in this way, is that unless there was a duty with respect to the inventory, the conversations that took place after the passing of the statute of limitations about inventory would not be continuous representation. They're tied together.
They are tied together, Your Honor, and a couple of things. The billing records with respect to perpetual inventory, they date back to 2005. They're in the record at 2731. There are references there. On 9/22, 2005, discussion with Fran. She was the on-site accountant at the time on perpetual inventory system, how to set up initially. Then in October of 2005, there's another entry there, help Fran setting up beginning inventory. That coupled with the other things that we reference regarding Ms. Darby Scott's testimony about what her expectations were when she met with Mr. Libach initially, all go to the inventory issues. Then, Your Honor, we talk about how there were responsibilities under the accounting standards and guidelines with respect to maintaining proper accounting records, properly supervising your employees, and then advising a client if there's an issue with respect to the accounting records. And that was going on continuously throughout the litigation. Those issues all pertain to the inventory, as I pointed out before in the three examples that the expert had set forth in his report regarding the work that Alex Partners, his firm, did. And then those just continue into the September and October timeframe, where there are myriad, not only accounting staff on site continuing the work that they were doing under the engagement letter, but then Mr. Libach, he then, and you're all familiar with the case law, if you then act to try to resolve the allegations of malpractice subsequent to the running of the statute of limitations, it tolls the statute. And there are myriad entries in his billing records in September and October where he's indeed doing that. And so those are things that the court below just completely did not take into account when it was dismissing the case on the first basis, which was the continuous representation doctrine.
Okay, thank you. Let's hear from your adversary.
If it please the court, I am Mark Anish, partner of Lewis Brisbois, Biscard & Smith, representing the respondent accounting firm. The lower court found numerous separate, independent grounds upon which to grant the defendant's motion for summary judgment. So much so that to attempt to gain a reversal, the appellant is basically claiming that Judge Kalish committed more errors than the 62 Mets. It's impossible. He correctly found that there was no duty assumed with respect to the inventory based upon the engagement letters and based upon the record itself.
Counsel.
So if your clients observed in the course of their work some indicators that the inventory, that there was no inventory control, that it was completely defective, and that the information they were getting was not satisfactory, are you saying that they had no duty even to bring that to the attention of the plaintiff?
I'm not saying that, but I am saying that they had no control over the inventory at all. They didn't know
I understand.
what was going on.
Yeah, I heard what you said, but I'm asking you a different question. Are you saying that if they observed that there was some defect in the inventory control, that they had no duty to do anything about that?
They arguably had a duty to do something about that, to advise, but there's nothing in the record whatsoever to show that they were aware of anything. In depositions, it was the employees of the plaintiff testified that the inventory was kept in a room or a closet open for any of their employees to go in. The inventory was loaned out. My client had no idea, bless you, my client had no idea of the goods going out, goods being returned, credits being given, unless they were given that information from the
Right, they got
plaintiff.
information, and at least according to the plaintiff's expert, the information that they had supporting some of the things that were put into Quicken didn't exist, or it was discrepant. Would that have raised a red flag? Were those sufficient, those deficiencies, at least enough to raise a red flag that there were problems with the inventory information that they were getting from the employees?
QuickBooks had nothing to do with inventory. Nothing.
But they had to do with the issuance of credits to customers like Neiman Marcus and the like. And didn't they need proper documentation before they issued those credits?
When you say before they issued those credits, who is they?
Meaning wasn't your client, wasn't that part of bookkeeping? The issuance of credit memos or documenting in the QuickBooks that there were appropriate credits given to the customers.
There's no evidence in the record to indicate there was any errors in the any evidence in the record to indicate that the information we received from their own employees was incorrectly put into QuickBooks. We have a right to rely.
I know you could rely. And so the information, the report of the plaintiff's expert, which said that there wasn't proper documentation, that doesn't, to justify what was in Quicken, that doesn't create at least an issue of fact about whether you had a duty of, well, you admit you had a duty of disclosure, but whether there was information that should have been disclosed.
The expert report, as Your Honor correctly put it, was relied upon, the expert relied upon Ms. Mayo, who is an employee, a biased employee of the plaintiff. She did an analysis years after we were gone, and she had no accounting background. She didn't have a college degree. She didn't even ask for the receipts. She testified she didn't even ask for the receipts at issue. So how could we be held responsible for receipts that were never given? And she admits she never asked for them. But the judgment below went beyond this duty. There was no proximate cause found. There was an expiration of the statute of limitations. With all due respect to opposing counsel, the conversations that were had with my client after the statute of limitations was expired was for the sole purpose of retaining my client to investigate the possible.
Right, I know that's your position, so it comes down to, would you agree with me, and I think your adversary did too, that the issue of the statute of limitations and the duty are closely related? So if in fact there was no duty, then the conversations about inventory can otherwise extend under the continuous representation doctrine.
Agreed.
If in fact there is a duty, however, there was a duty with respect to inventory, then the conversations about inventory that took place after August 30th, 2010 might affect the continuous representation doctrine.
With all due respect, I'm not so sure of that because there was a different duty assumed. They wanted us to investigate whether or not there was anybody stealing.
Yeah, they wanted you to investigate what they hired Alex Partners ultimately to do, no?
Yes, that's
All
what they hired, but they wanted us to do a forensic audit. And we increased the price from $25 an hour, which we were charging back in 2003, to a price that Ms. Scott didn't want to agree to. So just one last thing I want to say before I go. Beside blaming her bookkeeper, by the way, we were there once a week, starting at $25 an hour, up to $200 an hour, once a week. How could we be considered the de facto accounting firm when we were there once a week? But she blamed, prior to blaming the bookkeepers, my clients, she went to the owner of the company, Ms. Darby Scott, went to the police and the DA on 3 prior occasions before blaming us, blaming 3 separate employees for theft. The record clear, and there were no charges brought. The record clearly shows that, with all due respect, Ms. Darby Scott is not a good businesswoman. The company never made money for 7 years. No other questions? That's all I have. Thank you.
Thank you. All right, we'll hear rebuttal.
If I could address something initially, and that is the expert report by Mr. Brian Jenkins at Alex Partners. And once again, we heard what we've been hearing in the briefs, and that is the only thing that Mr. Jenkins relied on was the work of Ms. Sandy Mayo after the fact. And I asked the court to look at the record at page 2924, Roman numeral 2, where Mr. Jenkins starts to set forth the work of Alex Partners as it related to the...
What was the page?
Excuse me?
What was the page?
The page is 2924, Your Honor.
Thank you.
And the heading is Alex Partners' review of plaintiff's books maintained by defendants, observed invoices from November 2004 through October 2009 with supporting documentation that is either incomplete or inaccurate.
So they actually, those Alex Partners employees looked at the invoices and for the supporting documentation.
That's right. And Your Honor, as an example, on the next page, 2925, he points out, in these 118 instances, a credit memo was recorded in the QuickBooks accounting system satisfying an outstanding invoice with no supporting documentation. In many cases, a comment in QuickBooks reflects that goods were purportedly brought back to the showroom, where there is no explanation at all. Yet invoice numbers do not show up on the Bergdorf-Goodman RTV schedule. They actually went and they looked at what the return to vendor report that Bergdorf-Goodman had, and they were not able to reconcile those records with the accounting records that were put together by Mr. Liebach's firm. What Ms. Mayo did is she just attempts to calculate the actual damages. And as Your Honors know, as long as on summary judgment, if we can show that if there's a departure from the standard of care and that departure of standard of care gives rise to an inference that there's a loss caused by the
How-
malpractice.
Did her analysis of damages also take into account the issue of proximate cause?
No, it didn't. It just takes into account, it actually,
So it didn't really calculate damages, it calculated money that your client couldn't account for.
well,
But to call them damages, there would have to be causation related to defendants.
that's right, Your Honor. With respect to what Ms. Mayo did is she was able to reconstruct what was actually missing in the inventory. And then she was actually able to reconstruct what the cost was associated with those things based on the records that she had put together. And those things, those are for another day, Your Honor, and those things, according to Mr. Brian Jenkins, the methodology that she employed to do that is consistent with what experts in the field would generally rely on. And tellingly, something that is also left out of respondent's brief, this court has said, as long as that person upon which the expert was relying is subject to cross-examination at trial, then that would be permissible for the expert to rely upon. And so, as I said earlier, what he was relying upon was the methodology that was employed and saying that was consistent with the practice that he would employ. Thank you, Your Honors.
Thank you. Thank you both. Orthon versus Nick and Duke. You may proceed.
May it please the court. Elon Dobbs for Plaintiff Oddthan. Subject to the court's questions, I'd like to focus this presentation on two issues. First, that Supreme Court erred in dismissing Oddthan's claim that landlord's June 2021 statement that it would never sign any version of a cure agreement because no cure is warranted constituted a repudiation of the party's lease. And second, the Supreme Court erred in finding that the limitation on liability provision of the lease, section 3309, bars recovery of damages for the complaint's first cause of action. As for the first issue, Supreme Court held that because Oddthan has taken the position that landlord's refusal to sign a particular version of a cure agreement in 2015 on the ground that that agreement provided more affordable housing than was required to satisfy the harassment cure, Oddthan is therefore subsequently barred by an election of remedies from claiming a right to terminate the lease based on a later breach by landlord. And this was error for two reasons. First, what occurred in late 2015 did not, as the cases and other materials in our briefs pretty clearly lay out, give Oddthan the right to walk away from the 88-year lease, because landlord at all times until 2021 made clear that it would sign a cure agreement that contained fewer square feet of affordable housing.
In fact, make an allegation in their complaint, though, that failure to agree to the cure agreement was a breach of the lease, and therefore take that position in litigation?
It was a breach of the lease. That is our position.
Right, so if your position was that the 2015 refusal to cure was a breach of the lease, why wasn't that an election of remedy on your client's part by taking that position that that was a breach? Didn't it then elect to say it's a breach, therefore giving up its right to later seek a repudiation?
There are two answers to that. The first is that that breach was not a total breach of the agreement. The landlord, at the same time that it said it wasn't going to sign this version of the cure agreement, said that it would sign a version of the cure agreement in the future, and that the issue to be litigated was whether this gave enough square footage, or rather contained too much square footage of affordable housing. Landlord...
Isn't the question how your client treated that action, or what position your client took in response to that action?
It is not, in fact, because in order to give the election of remedies in the first place, the breach must be accompanied by a statement that we're not going to perform at all. In this case, it wasn't. But even if you think that that's a close question, even if that was a material breach that gave my client...
They kept saying we're not signing. If they never, because it's very unusual what they did, saying we're never going to sign any. If they just kept saying we're not signing this one, we're not signing that one, we're not signing this one, we're not signing that one, then you never would be able to claim that it was a breach of the agreement?
I'm not sure what the answer to that question is, but I know that...
You don't normally have a situation like this where someone says, I'm never signing any version of the cure agreement.
That's true, but they did say that. And at that moment, it became clear that...
Were there any other versions other than the one in 2015?
There were not, because it was, we had made a, amended the complaint to assert that there...
To seek your remedy under the contract, the sole remedy, which was an injunction, to get them to sign it, and the court said issue of fact, which we're still waiting to resolve, right?
Correct, but what happened in 2021, in June of 2021, the landlord wrote and said, we will never sign any cure agreement because no cure is warranted. That had nothing whatever to do...
Why isn't that just a subsequent second breach of the agreement that they, and isn't that your position, in fact, in the litigation, that they initially breached it in 2015, and then their subsequent statement was a second additional breach?
Well, I think that the case law is clear that in order to be barred by an election of remedies, the breach has to be the same breach, and this is not the same breach. Judge Shinlin says in the ESPN case that we discussed at some length in our reply brief that if you do make an election of remedies to continue on with a contract, that does not mean that in response to a subsequent breach that you can't terminate a contract. And that's exactly what happened in that case. The network preempted a certain number of games in 1 year, and baseball, the counterparty, said, fine, we're going to continue on with the contract. Baseball did the same thing the network did the same thing the next year, exactly the same thing.
Why isn't this the same breach? Because both of them were the same breach of failing to sign the cure agreement, both of which prevented equally your client from going forward with its ability to develop the project.
I don't agree with that, Your Honor, because the landlord had said back in 2015 that there's a dispute as to whether or not this complies with the lease. And if you look at the obligation, section 14.01 of the, which is on page 88 of the agreement, one of the reasons the landlord can refuse to sign an agreement is a contention that it doesn't comply with the terms of the lease. What happened in June of 2021
I'm going to ask you to wrap up.
Is that they said, we are never going to sign anything. They didn't reference any objection to square footage or any of their previous concerns. They said, if presented in the future with an agreement, we're not going to sign this. And that is a different action. It does not concern the same facts. It is not based in the same putative concerns as the previous breach and the previous refusal. And if the court had said, ruled...
This isn't a wrap-up. Come on.
Does the court have...
I mean, the lights are for a purpose. Again,
I apologize.
What I've been saying to everybody today, we understand this is a long-time litigation. There are complicated issues. This is a premier issue. We have your briefs. We have the record. Clearly, we understand the case. Don't worry. You will get full consideration of your arguments, even if you feel like you would really like a lot more time to argue.
I have no doubt. If the court has no questions, I'll reserve my time for rebuttal.
Thanks. Thank you. Go ahead.
May it please the court, Your Honor. My name is Jake Beadle. I represent Respondent Cross Appellate Nick and Duke, LLC.
So why isn't it a different act when that letter came and said, we're not going to sign any cure agreement no matter what?
I think to answer that question, it's important that we keep in context what the allegations are on the complaint. This is an allegation of repudiation. And what that means is that prior to the time in which the contract or the breach was supposed to occur, we write to Odd Than and indicate that we are not going to proceed with our obligations under the lease. Our obligations under the lease accrued in 2015 Authen does not dispute that. The fact that we wrote a letter in 2021 simply reiterating that does not constitute a repudiation. The doctrine of repudiation is a species of breach of contract. And the reason it exists...
Right, it's a remedy.
Correct. And the reason it exists, it helps to put it into a bit of context. For example, if my adversary and I contracted and I was going to sell him widgets that were to be delivered in December, and then in November I contact him and say, you're not getting your widgets. Under a normal breach of contract, he would have to wait until December 1st and then say, they didn't come, that's a breach. That's not fair to my adversary because he may need to look for new widgets. He knows they're not coming. And so the doctrine of repudiation stands for the proposition that on November 1st, when he first gets the communication, he's free to declare the contract breached. In this case, there was a cure agreement. Again, there is no dispute that in 2015, Authen alleges, and we have to take their allegations as true, that Nick and Duke breached the lease by refusing to sign the cure agreement.
And it's only one cure agreement.
There's only one cure agreement, that's correct. The fact that a subsequent communication was sent in 2021, case law in the First Department is clear that that cannot, as a matter of law, constitute a repudiation. And I would point the court to Kaplan v. Madison Group Owners, which is directly on point.
So let me ask you a question. So let's say, you know, because now you're going to have a hearing. Now, why it hasn't taken place yet is beyond my comprehension. But, you know, you're going to have a hearing about whether you had the right under the lease to say we won't sign the 2015 agreement. And suppose you're right. Does the letter that comes in 2021, which says we're not signing anything, constitute a repudiation? Is it like an alternative in the event that there is no breach beforehand, but you're not signing anything?
Interestingly enough, this is an instance in where the procedural posture, a motion to dismiss, I believe actually assists defendant here, because Authen has alleged that we have breached the lease by refusing to execute it in 2015. We have to take that as true. That's their position. The fact that sometime in the future it may come out, at this point that's not something that is even, it's ripe at this point. It's mere speculation that that may or may happen. But the
let me stop you for a minute, okay? Because we do have concepts of alternative pleadings. I will say that in most circumstances, alternative theories come up at the same time. Here, it's kind of separated in time, and more stuff has happened. But even if we take the complaint as true as to what they plead, that is a conclusion. They concluded that you breached the lease. We don't have a fact. We don't have an established fact. That's their theory.
There's no alternative pleading in the complaint that we were not obligated to execute this PCA, and therefore a hypothetical future PCA could potentially have been repudiated. That's not an allegation in the complaint. Authen has not made that. And I don't think that that can support their theory of repudiation.
But here, it provides that the consent shall not be unreasonably withheld. How does that factor into everything?
Whether or not the consent was unreasonably beheld at this stage in litigation is no longer material. And the reason that is because if we unreasonably withheld consent, then their sole remedy, as 3309 states, Section 3309 of the lease states, was injunctive relief.
So in terms of alternate pleadings, you're saying that's not relevant? That section would not be relevant to whether they could plead in the alternative in terms of repudiation?
I'm sorry, I don't think I follow you.
I guess what I'm getting at is what you're basically saying is we have to accept as true that that there's a breach, that there was a breach early on when you first refused to sign the QR. But if it turns out that there was no breach and it was a reasonable conduct by the landlord, then he's out the box, he doesn't have a defense or a claim?
At this stage, no. In 2015, actually prior to 2021, prior to when they surrendered possession, they would have. The relief that they could have sought was injunctive relief, as set forth and as the parties bargained for in Section 3309 of the lease. But at this stage, unfortunately, and I could address this on rebuttal as I see my time is up, because they improperly surrendered the lease, unfortunately for Ogden, they no longer have any remedy because their own improper conduct by surrendering the lease has precluded them from receiving any of such relief. If the court has no other questions, I will return on the rebuttal.
No, thank you. Let's hear from your adversary in rebuttal. So let me swing into something else here. Why should you have repudiation when, in fact, one of the claims that you have and the court let go forward was the breach of the duty of quiet enjoyment? And you were basing that on, I got that letter in 2021, frustrated the purpose of the contract, we moved out constructively, we've been constructively evicted. Isn't that your remedy and not repudiation?
I think that those are two separate breaches of contract that the case law, as we've noted in our brief, can sit side by side together. There's an express provision, section 1601, I believe, of the lease, that's for quiet enjoyment, and I agree that the lower court correctly let that claim go forward. But we have cited chapter and verse law on what constitutes a repudiation, whether it's a material breach or a partial breach, and that two breaches that are different can each give rise to the right to terminate.
And even if you're right that that second letter was another kind of breach of the lease, really, why aren't you bound by the sole remedy on that as well?
Because it does not apply. The limitation on liability, which is what this is, will not be implied, and to be enforceable must clearly, explicitly, and unambiguously be expressed in the contract. The obligation to sign a cure agreement, to cooperate, is to cooperate, and Section 1401 obligates the landlord to cooperate in signing agreements that are consistent with the terms of the lease. 22 separate times in other areas of the lease, the parties use the words landlord's consent, landlord's approval. Section 33.09 does not reference cooperation. It talks about whenever consent or approval is required. Cooperation is not, consent or approval are not defined to include cooperation, and cooperation is not a synonym of consent or approval. And so the law is clear. When you're abrogating the common law right to damages, when you're limiting the liability of one contractual party, it has to be clear. The lower court outright said, and they outright say, well, what you have to do is you have to imply that because the word approve appears in another section of the agreement, that it must be brought over to the section where it does not apply, even though the parties knew how to use how to make something subject to landlord's consent or approval, and they did so 22 separate times, but not in section 14.01, which is on pages 87 to 88 of the record, and which governs the obligation to sign a cure agreement.
Okay, thank you. Let's hear from your adversary in rebuttal.
Thank you, Your Honors. I'll be as brief as I can, as there are a number of issues I'd like to cover. First off, with respect to the quiet enjoyment claim, that claim must fall along with the repudiation claim because it is based solely on the same June 4th, 2021 letter that is established to not be a repudiation. Auden does not dispute that in order to have an effective quiet enjoyment claim, you must abandon the lease within a reasonable period of time you are constructively evicted. Again, to go back, this works perfectly in line with the repudiation claim. They have refused to execute the proposed cure agreement since 2015. It has been 6 years since they...
Isn't the problem, though, I mean, the alleged problem with the repudiation claim is that they've already elected a breach, which is why arguably they can't bring a repudiation claim. But the breach of quiet enjoyment is a very different type of claim. They're saying by your repeated failure to sign any cure agreement, indicating you'll never sign a cure agreement, and sending 4 termination notices, you have clearly stated you are not going to let them peaceably and quietly enjoy the premises And it doesn't have the same block of election of remedies that the repudiation has, so why shouldn't that be able to go forward as a different type of claim?
The basis for why it is not effective is different, but actually, interestingly enough, it's the same set of facts. And the reason being that, yes, there is no election of remedies. However, there is a time limit on when you can abandon the premises after the purpose of the lease has been frustrated. You cannot wait 5 years, 6
Didn't
years.
something new happen by you stating, which again, it's a sort of a shocking thing to say, we're never going to sign any cure agreement. It's basically saying this case is never going to resolve, there's never going to be a peaceful resolution. We're going to keep sending you termination notices. We are never going to let you enjoy these premises. We're making it as clear as we can make it. And now is when we're really letting you know the party's over. We're never going to peacefully let you enjoy the premises.
Well, there are a few, I don't have much time, but there are a few different things that I would like to address with that. First off,
Just your most important point.
excuse me? Just,
What was the most important point? And we'll
So-
go back to the briefs.
I would point out that we do have an argument, which if you review the actual content of the June 4th, 2021 letter, that is not what the June 4th, 2021 letter says. But with respect to the idea that this is somehow a new allegation that we're now saying we'll never sign any cure agreement, this again goes back to the reason why a repudiation claim can't survive. And the reason being is that we were currently within 6 years of litigation, a mere 2 months from filing a note of issue, where we would have been compelled to execute the PCA had Audthen's theory of the case been correct, which again we have to take as true. They moved to compel us to sign that particular PCA. We were on the eve of trial. We would have gone to trial, and had they prevailed, we would have signed the PCA. We would have been compelled by the court to sign the PCA. This goes back to the original point as to why their theory of the case is so problematic. If you claim a repudiation, if you claim that a letter that comes years after a purported breach occurs, you have these kind of logical problems that it makes no sense anymore. It doesn't make sense how a communication 6 years after you've refused to do something could somehow change the facts as they stand. We refused to sign the agreement. They claim we refused to sign it wrongly. The letter changed nothing. And so you can't support a quiet enjoyment claim, and it cannot support a repudiation claim.
Thank you. Thank you both. People versus Avery Fleming.
Good afternoon, Your Honors. My name is Hillary Dowling on behalf of Appellant Avery Fleming. We are asking the court to reduce Mr. Fleming's sentence of 6.5 years jail and 5 years post-release supervision in the interest of justice. Leading up to the instant offense, Mr. Fleming was struggling with untreated mental illness and corresponding drug and alcohol abuse issues. He was 22 years old at the time of the offense and had no prior felony convictions. Mr. Fleming received psychiatric care while his case was pending, during which he
Counsel,
gained... Yes.
Could you address the appeal waiver? Because if we find that's valid, then we cannot hear, then whatever said, you know, and moving tales you tell us about your client, we can't really reach.
Okay, it's our position that the appeal waiver is invalid and unenforceable. First of all, the court's explanation of the appeal waiver was inadequate to ensure that Mr. Fleming understood the distinction between the right to appeal and other rights automatically forfeited by guilty plea. Although the court told Mr. Fleming that the appeal waiver was a completely separate condition of his plea, that did nothing to convey that it was not a mandatory or automatic result of pleading guilty. That issue is actually compounded by the fact that the court never explained what the appeal waiver was actually separate from, as it had yet to discuss the Boykin rights that were automatically forfeited by the guilty plea. Additionally, the court never explained the nature of the right to appeal itself, and then mischaracterized the consequences of waiving that right. The court said that he would be giving, that Mr. Fleming would be giving up the right to have a higher court review the proceedings today, was the words he said, as well as the length of the sentence. This incorrectly conveyed that Mr. Fleming was giving up his right to appellate review of the plea proceedings, which encompass non-waivable issues such as the voluntariness of his plea and the legality of his sentence. This error is also compounded by the fact that the court never informed Mr. Fleming that select issues survive an appeal waiver. Lastly, the written waiver is insufficient to overcome the court's inadequate oral colloquy because the court did nothing more than instruct Mr. Fleming to sign the written waiver. The court never ascertained whether Mr. Fleming read the waiver, discussed it with counsel, or was even aware of its contents. So in light of Mr. Fleming's age, limited experience with the criminal justice system, and his mental health issues that were well documented by 2 730 examinations while the case was pending, finding him unfit to proceed. The record's insufficient to establish that he appreciated the nature of the right to appeal or the consequences of waiving it. If there are no questions about the appeal waiver, I can return to my final points regarding the sentence.
You can.
Okay.
You may, yeah.
Sorry?
You may.
Thank you. Thank you. I believe that I left off with mentioning Mr. Fleming's mental health issues related to this case. As I mentioned before,
Didn't the trial court have those issues in front of them, when it imposed the sentence?
yes, Your Honor, but it's still a relevant mitigating factor that this court can consider with respect to the excessiveness of his sentence. I would also note that after Mr. Fleming was taking his proper medications and his mental illness was stabilized, he remained stable up until the plea and sentence when he fully accepted responsibility for his conduct by pleading guilty. And I would just note that his favorable response to medication and proper treatment, which he had not received up until this time, makes his prospects for rehabilitation substantially more pronounced.
Thank you. Let's hear from your adversary. You can proceed.
Good afternoon, and may it please the court, Levi Stope for the people. Your Honors, the defendant here beat his victim in the head with a hammer multiple times, so much so that the victim had to go to a hospital to seek medical treatment, all for what? To take their cell phone. He was indicted on robbery in the first degree, where he faced a maximum of 25 years, and then he was given a deal where he pled down to 6.5 years and 5 years post-release supervision for robbery in the second degree. That is a generous deal. I also want to point out something very important here, is while defense asked for a reduction, that 6.5 years jail is already completed. He was released this past April. And right now, that 5 years post-release supervision is exactly what he needs. If he has mental health issues, he can go out and pursue services. If he needs any other programming, he can go out and pursue it. And if he needs that oversight, the PRS is exactly what it's there to do. As to the issue of his 730 history and whether he fully understood what he was waiving that day, defense in their papers point to the Court of Appeals case Bradshaw. And in Bradshaw there, we see another defendant with similar 730 history, and the defendant there was being questioned by the court about whether he understood what appellate rights he was giving up. And the defendant in that other case, Bradshaw, responded by asking questions about mandatory court fees, which to the Court of Appeals suggested that maybe he didn't fully understand what rights he was giving up. They contrast that with another case, People v. Ramos. In People v. Ramos, another defendant with similar 730 issues is before the court, and during the oral colloquy, the judge asks him, here are some of the appellate rights that you're waiving, do you understand this? And he said yes. And I think the question for this court right now is whether our instant matter looks more like Bradshaw, where the defendant completely ignores the conversation, or if it's more like a conversation in People v. Ramos, where there's a back and forth. Here we can see in the transcript there is a back and forth. The judge talks about the rights that he's waiving, and the defendant answers in the affirmative, yes, I understand these things. No reduction should be put forth here. He has all the services he needs. currently on PRS. And unless this court has any questions, I'll rest on my papers and ask that you affirm.
Thank you.
Thank you.
Thank you. I'm going to briefly address respondent's argument regarding the waiver. Mr. Fleming's mental health issues is one of the factors that can be considered in the totality of circumstances about whether the appeal waiver is valid. But the stark errors in the oral colloquy is the primary problem with the appeal waiver. So I don't think that the entire focus of this court should be on just the fact that he presented with mental health issues. It's the problems with the court's mischaracterizations regarding the waiver, the appellate rights that he was waiving. I'll also note with respect to his sentence, at no point does Mr. Fleming minimize the serious nature of the offense. But that is one of several factors that must be considered in fashioning a just sentence. Furthermore, in response to respondent's argument, the fact that a greater sentence was hypothetically possible does not mean that the sentence Mr. Fleming received was substantially fair. As a first-time felony offender, it is our position that the sentence imposed based on all the mitigating factors already mentioned is unduly harsh, and we ask the court to reduce it in the interest of justice.
Thank you.
Thank you.
Thanks to both counsel. All right, the last case we have on the calendar today is Papadas versus City of New York. You can proceed.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for appellants. Petitioner Dr. Papadas was an incoming first-year resident. His provisional appointment as a resident was contingent on satisfying a pre-employment medical clearance, which he did not because he failed a toxicology screening because he tested positive for excessive levels of morphine. Under those circumstances, it was completely rational for Jacoby Hospital, for Health and Hospitals Corporation, to rescind his provisional appointment. It's a hospital. This is a condition of the employment. They have legal obligations. They can't have...
Counsel, was the hospital required to give him a second test after that first one?
They were not, Your Honor.
But once they started that procedure, and they did offer a second test, but then cut it short without following the procedures inside their own guidelines of if it seemed it was altered or compromised in some way to have him take a second test specimen. Was there some error there?
I don't believe so, Your Honor. It's undisputed that they didn't have an obligation to give him a second test. So I think it follows from that when we look at what actually happened here, it's not as if there was an initial agreement to allow him to take a second test that was rescinded. When the specimen was submitted that was outside the temperature range, which can indicate that it was adulterated or altered, at that point they decided not to send it out for testing. So it's not a situation where
the decision to provide him with a second opportunity to administer a second test, that was undertaken by the hospital, correct?
The hospital, I don't know whose initiation it was, but certainly the hospital agreed to provide it to him.
So once the hospital agreed, isn't the hospital bound to follow its own procedure?
I think if the hospital had relied on a second test, if they'd actually sent it for testing, they would have had to follow that procedure where they send the sample that's outside the temperature range and another sample. But I think given that this was purely...
Counsel, how can you get to reliance on what that second test would have shown when you don't follow your procedure in collecting the samples and submitting them for testing?
Correct, Your Honor. There's no reliance on what the second test would have shown. They're not. That's what I'm saying. It's not as if they are relying on what the second test showed or didn't show.
Well, you couldn't.
Exactly, they couldn't, but they're not obligated to give him a second test, and he doesn't have a reliance interest in a second test.
But follow me. So he's not. The hospital's not required to provide a second test, right? So why do you offer it? What I am troubled by is that you're within your entire right to say you failed the first test. That's it. It's over. But that's not what you did. What you did here instead is we're going to give you another opportunity. Here's take another test, and then the hospital doesn't follow its own procedure. And my question is, why shouldn't the hospital have to follow its own procedure?
Because they're not obligated to give the second test.
But they elected to. So once they elect to give that second test, or they agree to, you're saying that they still don't have to follow the procedure.
No, I'm saying they're allowed to change their mind. And they didn't send it out for testing. I'm saying that the fact that this is purely at their discretion means that they can change their mind, and that's not arbitrary and capricious under these circumstances. Okay. And I think the other issues that the Supreme Court Justice relied upon that we feel were improper and that was substituting the court's own judgment for the judgment of Health and Hospitals are outlined in our brief. There was the issue of the misspelling and the lack of a signature from LabCorp. And I think, I'm certainly happy to answer any questions Your Honors have about them, but I think our argument there is very clear in our brief about why those certainly do not render Jacoby's decision arbitrary and capricious. They're entitled to rely on a report from LabCorp, which I think is the country's leading sort of testing vendor, that says that chain of custody protocols were performed. That's on it. They're entitled to rely on that. And there's no genuine issue as to whether these were the test results that actually belonged to Dr. Papadas. I mean, there's identifying information on the report that matches his identifying information. And I think at this point, if Your Honors have no other questions for me, I'll reserve the rest of my time for rebuttal.
Any further questions? Thank you. Let's hear from your adversary.
May it please the court. My name is Matthew Weinick. I represent the petitioner, respondent Athanasios Papadas.
So he tested positive. Why is that not the end of the story?
Well, Your Honor, first of all, the lab report that that respondents or the city is relying on to say that he tested positive doesn't bear his name. I understand the arguments they're making that numbers might match, there might be some other identifying information, which frankly hasn't been disclosed to us.
Isn't the control number, aren't the control numbers and the fact that they match, isn't that really what's important?
No, Your Honor, the decision-making process is what we're looking at to determine whether there was an arbitrary and capricious decision.
Well, why would it be arbitrary for them to look at the information and even in the face of what looks like some technical errors, decide that, no, in fact, this was his specimen. It was his, right.
I understand the question. I might agree with Your Honor if that were the facts, but those aren't the facts. The decision maker testified at the hearing below. He did not testify that he took those steps, that he looked at the control numbers. He had an incorrect name that he continued to use throughout the hearing and never testified that he took any steps to verify that that was indeed the results for Dr. Papadas. He could have walked the court.
So your client denies that those are his results? Or he's just saying, gee, there are these technical stuff?
We can't be sure. We don't have an unredacted copy of whatever the identifying information that the city is relying on.
Mm-hmm.
So we don't know. We know that the result that they're relying on doesn't have his name on it. There were no verifying steps. That is an arbitrary and capricious decision to say, these results don't belong to this person, or at least we're saying his name doesn't match. How can you link that all together? If somebody goes to the hospital, there is identification at every single step to confirm this is your name. We're going to perform this procedure on you. We're going to collect these samples from you.
Counsel, that may be true, but this is quite different, right? So they collected a sample, and they provided a control number, and that control number matched. It's not like, when you go to a hospital, they don't stamp you with a control number on your forehead and say, what's your name? And then they match the control number. Here, the important thing is the control numbers matched. Why is that not the focus?
Because in the example I was giving about a hospital, there is checking of the control number along the way. Here, again, the decision maker testified about the steps he took. He didn't testify that he looked at the control numbers to verify that, yes, there is no problem with chain of custody here. The control number matches, this other identification. I'm not concerned about the name because these other things satisfy me that...
Are you disputing whether the control numbers matched?
I can't dispute that the control numbers match. I can suggest that the court did not accept that the documents submitted by the city should be submitted into evidence because there were questions about authenticity and reliability of those documents. But again, what I think is crucial here is the decision-making process. This isn't a question of substantial evidence under 78034. In that, we're looking at substantial evidence. In that type of a case, we're looking at, is there evidence in the entire record that would support the decision? This is a 78033 case where we're looking at, was the decision arbitrary and capricious? Were procedures followed? There wasn't. In addition to the name, I would point out that the chief medical officer of Jacoby testified that the chain of custody form must bear the signature of a receiving lab. Health and Hospitals produced a chain of custody form which doesn't have that signature. They're speculating about why that might or might not be. The fact remains, they don't have a chain of custody form with a signature that they testified is supposed to be there. They offered a document that doesn't have that signature. They have not offered an explanation in the record based on evidence and not conjecture of why that is. And again, looking at the totality of the circumstances here, there's a botched name, which the trial court suggested showed sloppiness in the way that the drug testing was handled. There's a missing signature on a form that is supposed to have a signature. There is deviations from established procedures with respect to the second specimen, and there is no evidence that there was any consideration of the exonerating evidence that Dr. Papadis provided about why there might be a positive result if the hospital believed there was a positive result. He submitted statements that said he was eating large quantities of seeded bread. Thus, like in many other drug testing cases, there is exonerating evidence, there is questions about the chain of custody. The decision with all of this in place is arbitrary and capricious, and it shocks the conscience, and the trial court had no trouble in reaching that conclusion either.
Thank you.
Your Honors.
All right, rebuttal?
Counsel, I have a question in terms of the chain of custody when the specimen was handed over to LabCorp and no signature. Inside the Appendix A, it indicates that at the end of the chain of custody, the responsibilities are then transferred over to the lab. Does that equal the requirement of a signature, or is it something else?
I think the LabCorp is supposed to sign I think there are multiple copies of this form. I think it looks like you sort of are pressing through it and you kind of rip it off and you keep yours copy. So the copy that was in the record was Jacoby's copy, which isn't going to be signed by LabCorp because it hasn't gone to LabCorp yet. And there was, LabCorp's copy is not in the record. I mean, this issue was never raised during the hearing. It was sort of done by the justice in the decision. But what is in the record is the actual report, which very clearly states on the front page of it that the chain of custody protocols, it confirms that they were conducted and done. And this is a rational review test. This isn't a sort of like a, beyond a reasonable doubt standard. It's entirely rational for Jacoby to rely on that when they get it back that says that LabCorp adhered to the chain of custody protocols. And I don't have anything else really to add on my affirmative argument. I would just simply note that I think certainly obviously our position is that this court should reverse and it should deny the petition and dismiss the proceeding. If the court were inclined, however, to affirm the arbitrary and capricious finding, I think it should nonetheless, for the reasons in our brief, it should strike the award of attorney's fees because they're not available in Article 78. It also should strike the portion of the paragraph of the order that calls for reinstatement because you can't be reinstated subsequent to the expiration of your contract. Thank you. I don't have anything else.
Great, thank you. A special thanks always to the last case on the calendar for your patience. Thank you.